Court does call the case of the people of the state of Michigan versus Ronald Fleming.
Good morning, Your Honor. Ashley Lundy for the people.
Stephanie Cannon on behalf of Mr. Fleming, who should be appearing via Zoom. Yes. Mr. Fleming, could you state your name for the court?
Ronald Fleming.
Thank you. Your Honor, today's the date and time to go over the competency evaluation, or I'm sorry,
Competency review.
the report. And the report has been provided to me. I do believe the prosecutor has a report.
I received it, Your Honor.
And in the report, it is indicated that my client is not competent, but they do believe he can be restored to competency within the statutory timeframe. So, Your Honor, we are asking, we will stipulate to those findings, and we are asking for another hearing regarding competency.
And Your Honor, I'm sure the court recalls we've been pending competency for quite a while on this file, but the defendant, I do believe, was admitted to the forensic center in June. So he's been there now for about a month and a half. So I'm optimistic that we may actually be able to get the treatment restored and done at this point. I would request also an adjournment and would stipulate to the findings in the report as provided to myself, defense, and the court, and ask the court to continue the order for his treatment and allow him to attempt to regain competency.
And just so that we're all clear, the report that I'm looking at is the July 15th report. She needs this.
Yes, Your Honor.
Yes, Your Honor.
All right. Based upon that report, the findings are, and it's been stipulated to by the parties, that the defendant still remains incompetent to stand trial at this time. The court will then continue that finding. And I will set a review hearing. Give me 90.
October 16th. 9 a.m.
October 16th, 2025, 9 a.m.
Thank you very much, Your Honor.
Thank you, Your Honor.
Bond will continue. Thank you, Mr. Fleming.
Thank you.
Court calls case People versus Tariq Wilson.
Stephanie Cannon on behalf of Mr. Wilson, who should be appearing via Zoom. Mr. Wilson, could you please state your name for the record? Mr. Wilson, could you state your name for the record, please?
Mr. Wilson, can you hear us? Not sure if he can hear us or not. I heard. All right. I'll pass him. Hear us. Court does call the case People versus Carista Riopel.
Good morning, Your Honor. Requesting permission pursuant to Michigan Court Rule 0 under the supervision of a actually long.
Oh, really? Okay. Permission to practice is granted.
Thank you, Your Honor. Christina Berg, hearing for the people.
Morning, Judge Mike Gaddy, Assistant Public Defender on behalf of Ms. Riopelli, who is here via Zoom. If you could state your name, ma'am.
Carell Brown.
Your Honor, I have had a chance to speak with Ms. Riopel, and we are asking to adjourn this matter so I can visit her and go over the mitigation information that we have prepared. I'd like to do that in person with her. So I'd ask the court for a couple of adjournments so I can accomplish that.
So you want 2 weeks or 3 weeks out?
Maybe 3 weeks, Judge.
August 7th. I think it's okay. Probable cause conference will be adjourned August 7th, 2025, 9 a.m.
Thank you, Judge.
Thank you.
Continue. Thank you. Court calls case People versus Amanda Stardutz.
Morning, Your Honor. Mariah Thomas, Assistant Prosecutor on behalf of the people.
Good morning, ma'am.
Good morning, Your Honor. Kerma Dadush on behalf of Ms. Skardautis. Ms. Skardautis, can you please state your name for the record? Oh, she's not unmuted.
I don't know if she can. Where
Amanda,
she's at MDOC.
can you try to see if someone can unmute you at MDOC?
You're trying to force it. Oh, we got her. Ma'am, can you state your name, please?
Amanda, can you please say your name for the record?
I don't know if she can hear us.
Earlier, it should be.
Yeah, but she's not responding. They're at different facilities, correct?
No.
Yes.
Oh.
The two that couldn't hear me, because I got
Oh.
two that are unmuted but cannot hear me. All right, I'll pass that matter.
Thank you, Your Honor.
You'll contact or try. Court does call the case, People versus Mariah Thomas.
Chairman Dadush, on behalf of Ms. Thomas. Ms. Thomas, can you please state your name for the record? Okay.
Ms. Thomas, if you can hear me, if you can wave your hand, I would appreciate it. Yeah, I'm not getting.
My name isn't Miss Thomas.
Oh. Yeah, I was gonna say, I don't think that's her.
Okay, what
No.
is your name, ma'am?
My name is Anitra Coomer.
Got her.
Judge, she was adjourned via step.
She was adjourned.
And Ms. Coomer, just for the, I'm coming to see you on Monday. I have.
Okay.
Yeah.
Okay.
All right, sorry about that. I
Okay.
guess it was adjourned
That's
via
fine.
step. Thank you, ma'am.
Yeah.
Maybe they can put Amanda in that.
Pardon? So do we have Miss Thomas?
So that was Miss Thomas because.
Yeah.
Yeah, so no, we don't have.
Okay. This is going well.
Well,
So you want to adjourn that out?
well,
Was
Miss
she,
Thomas's?
pardon?
No.
Is Miss?
Miss Thomas is in the MDOC, dates of April 11, when that facility signed.
Oh.
I can come get-
Okay, so she's at 11.
Yes.
We are adjourning Amanda. I think she has to say her name for the record anyway.
She does.
Okay, thank you.
Well, I have to make sure it's her too.
I believe that is her.
Amanda? I just don't know why we don't have. That's it, Huron Valley.
Yes.
See if you can get through to them. Court does call the case of the People versus Denell Young Senior.
Good morning, Your Honor. Jeff Green, Special Assistant Attorney General, here on behalf of the people.
Good morning.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender, on behalf of Mr. Young, who's here to my right. State your name, Mr. Young.
Denell. What are we doing?
Your Honor, I did have a chance to communicate with Ms. Williams from the AG's office. At this time, Mr. Young would like to set this matter for the preliminary examination.
All discovery is complete.
Yes, Your Honor.
The people have their witnesses available the 29th.
29th, yes, Your Honor.
Preliminary examination in person, July 29th, 2025, 9 a.m. That's before Judge Barr.
One thing, Your Honor.
Bond will, thank you. Bond will continue.
Thank you, Judge.
Your Honor.
You have a question, sir?
Oh, yes, Your Honor. I just wanted to make sure that we repeat it again on the record that we've made a pre-preliminary exam offer. And as of the date of the preliminary exam, we'll be withdrawing that offer. Just want to make sure the defendant is very clear about that. Thank you, Your
All
Honor.
right. Understand
Yes,
that.
yes, we have gone over the offer, Your Honor. It's the people's, I don't want to say standard, but the offer that they generally make.
Okay. And you understand that if it proceeds to prelim, it will be withdrawn.
Yes, sir.
All right. Very good. Thank you.
Thank you. Good morning, Your Honor.
Thank you. You too, sir. Court calls the case, People versus Hector Gonzalez.
Prisoner hearing for the people.
Morning, Your Honor. Michael Vincent on behalf of Hector Gonzalez.
Good morning, sir.
Mr. Gonzalez, put your name on the record. Hector Gonzalez, Your Honor.
Thank you.
Your Honor, today's date, time for probable cause conference. We wish to have a prelim exam on this matter.
All right, all discovery is complete.
Yes.
We'll have their witnesses available the 29th. Preliminary examination in person, July 29, 2025, 9 a.m. before Judge Washington. Who are you? No, I'm kidding. I'm kidding. I just haven't seen you in a while. I didn't recognize you. The 29th is not. Any objection from the people if I go to the next day?
We're gonna check to make sure he's there. Okay. Just make sure.
August
he's there.
5th.
Yeah.
Set preliminary examination, August 5th, 2025, 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Bond will continue. Thank you.
Thank you, Your Honor. Thank you, Your Honor.
Court does call the case of the People versus Jessica Hafner.
Your Honor, after that order requesting permission to count this under NCR 8.120 under the supervision of PAG.
Who? He has an intern?
Yes, several.
He does?
Very good.
He's not old enough. All right, permission to practice is granted.
Thank you. I've got a nice phone report.
Thank you, Your Honor. Today's the date and time set for probable cause conference. We are just asking for a brief adjournment at this time. The court should have the.
Did you state your appearance?
I'm sorry, Judge Calvert on behalf of Ms. Hafner. Ms. Hafner, please state your name for the record.
Jessica Hafner.
Thank you.
Judge, we're just asking for an adjournment.
You're looking for an adjournment of this?
Yes, Judge.
All right. You want the 31st or the 7th?
The 7th? The 7th, please.
Probable cause conference will be adjourned August 7th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you, Judge.
Wait on the hallway for me. I can talk to you.
Mr. Wilson, can you hear me, sir?
Yes, sir.
Okay. I think something happened the first time, so let me call your case. Court does recall the case of People versus Tariq Wilson.
Stephanie Can on behalf of Mr. Wilson, who is appearing by Zoom. Mr. Wilson, could you please state your name for the record?
Tariq Wilson.
Thank you. All right, what are we doing?
Your Honor, I do believe I turned in a German form on this. When I attempted to make contact with him, MDOC let me know that I had to go through a lengthy process. I've started that process. He can add me to his phone call, to his visitations, and I should be able to speak with him. But in the meantime, I have filled out the application, turned it in, and I'm waiting to get approved as somebody who can come to the jail. So I'm asking for an adjournment. I do believe I asked for a 3-week adjournment because of the process.
That objection, probable cause, August 7th, 2025. Thank you, sir. Court does call the case, People versus Ramen Muhammad.
Good morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
Carell Brown on behalf of Mr. Raman. Mr. Raman, please state your name for the record.
Ramen Muhammad. All right.
And Your Honor, we will be waiving the preliminary exam today. I have a form I'm going to ask Mr. Muhammad to sign. All right.
And sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses are committed and that you committed them?
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Your turn.
Judge, this time, waive formal reading, stand mute.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for
30 with Judge Cummings.
July 29th, 2025, 1:30, Judge Cummings.
Thank you, Judge.
Thank you. Bond will continue. Lee, can you, sign off on it? Court does call the case of the people versus Matthew Brown. Matthew Brown?
Yes, I am here, Your Honor.
Correct. Ms. Constantino?
Some reason you can't get through.
Sorry, Judge.
No,
I hit the wrong button. Good morning, Your Honor. Christina Costantino on behalf of Matthew Brown.
Hey, good morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
all right.
And Your
And
Honor-
what are we doing?
Your Honor, I was just recently appointed to Mr. Brown's case, given that we would be asking for an adjournment of the probable cause conference.
All right. Probable cause conference will be adjourned to August 7th, 2025, 9 a.m. Bond will continue.
Thank you very much.
Thank you.
Thank you.
Amanda. Court recalls the case of People versus Amanda Scardudos.
Yes, sir. Yes, sir.
Here's now.
Good morning, Victoria Burton here, Chief Assistant Prosecutor again appearing on behalf of the people.
And Kerma Dadush on behalf of Ms. Scardudas. Ms. Scardudas, can you please say your name for the record?
Sure, my name's Amanda Lynn Scardudas.
Thank you.
Your Honor, we have come to a plea agreement. Unfortunately, we came to that agreement after the plea form was due, so we're asking for a very brief adjournment so that we can have that ready for the next court date.
2 weeks out. That was July 31st, 2025, 9 a.m. Bond continue.
Thank you. Ms. Scardudas, I'll talk to you, okay?
Okay, thank you so much. Y'all have a very wonderful day.
You do the same. Thank you.
Thank you.
Here, he'd shoot it.
I'm not.
You're not gonna. Darn. All right. Court does call the case, People versus Andrew Patton.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Christina Costantino appearing on behalf of Mr. Patton. Mr. Patton, can you please state your name for the court?
Andrew Spencer Patton.
Thank you. What are we doing on these?
Your Honor, with regards to the case number ending in 5110, it's my understanding that discovery is complete to my knowledge, and we would be asking to have that matter set for a preliminary exam. But with regards to his other matter ending in 5154, I have just been appointed late last evening to that matter, so I would be asking that the PCC be adjourned so I can obtain discovery.
In the case ending in 5154, probable cause conference will be adjourned to August 7th, 2025, 9 a.m. Bond on that matter will continue. On the other matter, would the people have their witnesses available? Would the parties be available? Will the 29th work, or did you need another day?
The 29th will work, Judge.
Will? Okay, fantastic. All right. Preliminary examination in this matter will be set in person, July 29th, 2025, 9 a.m. That's before Judge Washington.
Thank you very much, Judge.
Thank you. Bond will continue.
Thank you, Your Honor.
Thank you. Calls the case, People versus James Williams.
Christina Costantino appearing on behalf of Mr. Williams. Mr. Williams, can you unmute and state your name for the court?
Yes, ma'am. James Williams.
Your Honor, this is a date and time set for PCC. We have been working on mitigation, but our mitigation specialist does need some additional time to complete a mitigation report, given that we would be asking for an adjournment of the PCC.
Without objection, August 7th, 2025, 9 a.m. Bond continued.
Thank you very much, Judge. Have a good rest of your day.
Thank you. You too.
Thanks.
Court does call the case People versus Richard Atkins.
Ron Brown appearing on behalf of Mr. Atkins.
Morning, Mr. Brown. Your name, sir?
Kiwan Atkins Richards.
I'm sorry, Your Honor, I was listening for Kimani. I didn't realize that was him. If you're Richard McDuffie for the people.
All right.
We'd ask the court to set this for examination.
Discovery is complete.
Your Honor, I have a request from counsel for the 911 call. I believe that will be here by some point next week. I just want to confirm, since Mr. Atkins Richards is a co-defendant along with Mr. Carell Brown, who's represented by Mr. Carell, that counsel is seeking to hold separate exams in that whole exam.
Separate exam.
When is that other one set?
Mr. Brown is up for CCC probably right after this record from today's docket.
We'd like the earliest date possible.
Judge, just for the record, Robert Kilwell, I was just appointed, but I met with Mr. Brown last night and he wants to proceed to exam.
All right.
Just for your info.
Very good. Preliminary examination in this matter will be set July 29th, 2025, 9 a.m. That is before Judge Barr.
Thank you.
Bond will continue.
Thank you.
Case People versus Bianca Raul. Well.
Morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor, again appearing on behalf of the people.
Carell Brown on behalf of Ms. Raul. Bianca, please state your name for the court.
Bianca Raul.
Your Honor, Anali is en route to your staff.
All right.
And so I don't think that we need to worry about this matter much further.
Okay.
Before it could get to you, unfortunately, I'm sorry.
That's fine.
Okay.
Any objection to the dismissal?
What do you think, Bianca?
No.
No, Judge. No objection on this one.
Case is dismissed. I'll sign off on that when we. Court does call the case People versus Carell Brown. This is the co-defendant.
Yes.
Hey, did I get 29th bar?
Good morning, I'm Rob J. Kill on behalf of Mr. Carell Brown. Carell, would you state your name?
Carell Brown.
Judge, I would, like I said, I was just appointed, but again, we met last night for a significant period of time. I do have the discovery. He's seeking a preliminary exam in this matter.
All right. People have their witnesses available on the 29th. Preliminary examination in person, July 29th, 2025, 9 a.m. before Judge Barr.
Thanks, Judge.
Your Honor, just confirming again for this record, since Mr. Brown requested a separate exam, that these are on the same.
I'm going to let Judge Barr decide whether or not the exams are held jointly or separate.
Okay.
I put them both before him. He can make that decision. Thank you.
Thanks.
Court calls case People versus Taylor Adams.
Assistant Public Defender Jay Bellinger on behalf of Mr. Adams, who approaches. Mr. Adams, can you please state your name for the record?
Taylor Adams.
Thank you.
Your Honor, I am just requesting a 3-week adjournment for purposes of completing mitigation and having that reviewed by Ms. Londy.
Without objection, August 7th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. I will be giving you a copy. Thank you, Your Honor.
Court calls case People versus Kimani Hamilton.
Ready, Your Honor. Good morning, Rob J. Kill on behalf of Mr. Hamilton. Judge, would you state your name for the record?
Kimani Hamilton.
Judge, I met with him last night. There's a lot of issues that we have to discuss. I'm asking for a brief adjournment.
Probable cause conference will be adjourned to July 31st, 2025, 9 a.m.
Let me see. It.
Bond continued.
Thank you, Your Honor.
Court calls case People versus Abdul Raman Ali.
Council Lonnie for the people.
Mr. Council Spender, on behalf of Mr. Al-Daishi, he's now approaching. Please state your name for the record.
Rahman Al-Dai. Anti pockets.
Go ahead. What are we doing?
At this time, Your Honor, we'd be setting this matter for a preliminary exam. To my knowledge, all discovery is complete.
People have their witnesses available on the 29th.
We'll try, Your Honor.
Preliminary examination in person, July 29th, 2025, 9 a.m. That is before
Judge Washington.
Judge Washington.
Thank you, Your Honor.
Thank you. Bond continued. Court calls the case People versus Demond Bransford.
I'd like to class of hearing on behalf of Dominic Billings.
Pardon?
State your name for the record.
Demond Bransford. Thank you.
Your Honor, at this time, we would like to waive over to circuit court.
Sir, is that correct?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants found over to circuit court on all three counts. Your turn.
We acknowledge the information and receipt of the information, and we waive its reading, and the client stands mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. As to all counts, pretrial will be set for
July 30th at 1:30 with Judge Conlon.
July 30th, 2025, 1:30, Judge Conlon. Bond will continue.
Thank you, Your Honor.
Court does call the case of the people versus Amar Amadu. Ms. Cannon,
Oh, I've got it, sorry.
so I don't get to yell at her, I get to yell at you.
No, I'm sorry, she just kind of handed them off to me, Your Honor, and left. So, I'm sorry, what was the name, Your Honor?
I'm with you.
Yes, thank you, Your Honor. Student Attorney Kara Rosingen requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Hannah Apple on behalf of Mr. Amadu.
Permission to practice is granted.
Thank you, Your Honor.
Where's your client?
I'm sure I don't have any idea. I'm sorry, you'd have to ask Miss Cannon. You'd have to ask Miss Cannon.
I'm going to reiterate, I'm sure I have no idea.
But we are asking for an adjournment in this case, Your Honor. We're requesting a 2-week adjournment.
You can hand me that, it's not gonna happen. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Court does call the case of the people versus Troy Brumfield.
Assistant Public Defender Hannah Apple here on behalf of Mr. Brumfield, who's approaching now. Mr. Brumfield, will you state your name for the record?
Troy Brumfield.
Thank
you.
Your Honor, Mr. Brumfield wishes to waive his preliminary exam today.
All right. Is that correct, sir?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Thank you. Your Honor, defense would acknowledge receipt of the information, waive reading, and my client would stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 28th at 1:30 with Judge Hamilton.
July 28, 2025, 1:30, Judge Hamud. Bond will continue.
Thank you.
Sign off. Court does call the case, people versus Dominic Billings.
Student Attorney Kara Rosengren, on behalf of Mr. Billings, could you say your name for the court?
Dominic Billings. All right.
Your Honor, Mr. Billings is going to waive his right to preliminary exam today.
All right. Sir, is that a correct statement?
That is.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, I do.
Understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Mr. Billing waives formal reading and stands mute, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
September 8th at 1:30 with Judge Hamud.
September 8th, 2025, 1:30, Judge Hamud.
Thank you, Your Honor.
Bond will continue. They're gonna need that. I didn't pull it out. Court does call the case of the people versus Robin Finney.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Ms. Finney, who's approaching. Ms. Finney, can you state your name for the court?
Yes, Robin Lee Finney.
Thank you.
Thank you. And Your Honor, I apologize. I do have a green sheet. I am requesting an adjournment, a 2-week adjournment in this matter for continued discussion with the APA.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case of the people versus April Black.
Stephanie Cannon on behalf of April Black.
Thank you.
And Your Honor, in this case, we are asking for a brief adjournment for mitigation purposes. My client has provided me some information. I need to provide that to the prosecutor's office.
Probable cause conference, April 7th, or August 7th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor. August 2nd. Oh, you want to address the cover? Your Honor, may I address bond? I'm so sorry. May I address?
He's out.
What?
Go ahead.
Oh, I didn't hear what you said, Your Honor. I'm so sorry. Your
I'm
Honor.
happy to change it.
Oh, he's out.
Go.
You're not going to change it?
No, I don't know what you're asking.
Oh, so Your Honor, my client is currently on tether. We're asking that the tether be removed. I have reviewed her file and the information in this case. She is charged with malicious destruction of property and resisting an officer. The police report itself is replete with information that has nothing to do with her resisting charge. It's my understanding, since then, she's been very cooperative with the police regarding the situation that pulled the police to the scene, which was a shooting. My client wasn't a part of the shooting. She was a victim of the shooting, her and her mother. In their haste to get away, the police did stop them. And my client has allegedly done some behaviors where she destroys a little bit of property, maybe we'll say, and she's going to pay for that. She understands that she has to pay for that, and she did resist. However, my client in that time frame was exceptionally emotionally distraught from the shooting. Her whole thing was to get away from the scene, to leave. And yet somehow, some way, my client, and again, she's done lineup, she's done everything the police have requested of her regarding that shooting. She has no other criminal history. She's not a threat to the public. She's come to every court appearance, and she will continue to come to every court appearance. We're asking that the GPS tether be removed, Your Honor. In addition, it won't allow her to go see her mom when her and her mom were trying to get away from the situation. And so she's also confused as to why the court is keeping her from interacting with her mom when her and her mom were victims trying to get away from the scene.
Response.
Yes, Your Honor, I did your agreement on this, so that perhaps gives me a little bit more insight. So what happened here is, in my understanding, is there was not actually a shooting, it was an FA of Ms. Black's mother. And the reason that she has that color is that Ms. Black is accused of repeatedly trying to go to the home of the people she believed did that, which is just a few doors down from her mother. So there's no order that prevents contact with her mother. The order prevents contact with her mother because at the time this happened, Ms. Black was visiting her mother And when the police responded, they actually used a lot of restraint with Miss Black as far as they tried to just get her to calm down because they understood she was upset. She repeatedly told the police that she was going to the residence where the suspects were. And they kept telling her, no, you're not. And she kept telling them, yes, I am, and kept trying to walk over there. They had to physically stop her multiple times. Eventually, they ended up having her sit in the car, try to give her some time to calm down. When they let her leave from the car, she again said she was going there. And so, Your Honor, it was because she refused to calm down as far as going to that location, that there was that concern for safety. So there's no attempt to stop her from seeing her mother. It's to keep her from going to that other location that's just a few houses down.
Your Honor, and I'm sorry, I'm sorry, because she just finished. I'm so sorry. Please continue.
So that's why she had the tether. There could not be a hot zone because she lives, Ms. Black lives so close to the location. And
Correct.
so to resolve that issue, it was a tether with a no-go instead of a tether with a hot zone. So that's why there's that.
Gotcha. And I don't see an order prohibiting contact with the mother, so I don't know where that.
So she goes there, she takes her children there. This is somewhere that she used to go every single day because she takes her mother there. Now, we understand that she's not been charged for the felonious assault of anyone. She didn't go to those people's houses. She's not trying to go to those people's houses. She's calmed down a great
No, but the
deal.
allegation is that she tried to go there on that night, that she tried to go toward where these people were that committed the other alleged act.
Yes, Your Honor. So that is the situation, but my client doesn't want to go there. She's calmed down. She's never been there before. She has no intention of going to these people's house. It was just an emotional situation at that time. She's not that person, Your Honor. And she's asking for the court to give her the opportunity to show that that was a momentary lapse of judgment that she will not go back to.
Motion to modify bond is denied. Bond will continue. The GPS will continue.
Thank you, Your Honor.
Court does call the case of the people versus Antoine Brown.
And then on behalf of the people, Your Honor.
Carolyn Foster Tucker on behalf of Antoine Brown.
Your name, sir?
Antoine Brown.
Thank you.
And Your Honor, we are requesting a preliminary exam in this matter,
All right. All discovery is complete.
to my knowledge.
People have their witnesses available the 29th.
Yes, Your Honor, and I do believe as far as discovery, we did request the 911 call early this week, so it should be here prior to exam.
Okay. Preliminary examination in person will be set July 29th, 2025, 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Oh, you're on your way. Court calls the case, people versus Ibrahim Diakite.
Alexander on behalf of the people, Your Honor.
Assistant Public Defender Nicholas Bukovich, on behalf of Mr. Diakite in matters that end in 1232 and 1233.
Morning, I'm Rob J. Kilwell. Judge, I'm on 5153.
Okay, what are we doing? Sir, Mr. Dick, he's still muted.
Yeah. Jim, why is he brought up?
Oh, there he is. Sir, can you state your name, please?
Ibrahim Diakite.
Okay. What are we doing?
In the matters that I represent, Mr. Diakite on 1232 and 1233, we will be requesting a set for a preliminary exam. To my knowledge, all discovery is complete in both of those cases.
Same with 5153.
You want an exam set?
Yes, Your Honor. I did meet with him last night. So keep an eye on.
People have their witnesses available the 29th.
We'll do our best, Your Honor.
Preliminary examination will be set in person July 29th, 2025, 9 a.m. before Judge Washington.
And Your Honor, when appropriate, my client would like me to address bond.
Go ahead.
Yes, Your Honor. Mr. Diakite would like me to request a release on tether. He does not reside at the same location as the complaining witness in the 1232 case. Prior to incarceration, he began working full-time as a caregiver. He'd like to be able to return to that work. He does not have to be, he has no reason to be in contact with the alleged complaining witness in this case, no children in common, no residents in common. He does have his own transportation, and will be able to return to court. He does have ties to the state of Michigan, as he has family who resides within the state in different cities. So he'll be requesting a tether with a release on tether, personal reconnaissance bond for release on tether in his cases.
Your Honor, just two things on my case. I'm trying to figure out what the bond is. Does your record show what the bond is on the 23 case?
The 23 case bond is 1,010%.
All right, thank you, Judge. I would just echo that, Judge, request for bond. And again, this is a 23 case that happened in the jail.
Response?
Your Honor, I would object to any modification of bond. This defendant is looking at 3 cases here, and I'll go through each one by one. In his R&O case, he is an officer tried to stop the fight and told the officer that he was going to kill him when he got out of jail. At his next case, he was throwing rocks at someone's windows. Officers arrived, saw a motorcycle leaving, confirmed it was the defendant, and a pursuit began where he reached speeds of over 100 miles per hour in a 45-mile-per-hour posted zone. He was caught after the motorcycle had stalled, and the motorcycle turned out to be stolen. And then in his third case, him and the victim, who were working together, had a dating relationship. An employee at that restaurant called 911 to report that the victim had been dragged from the women's restroom, kicking and screaming, to a car, and the colleagues at work had saw visible scratches on her face. And after being put in the car, the defendant then drove away, and the victim jumped from the car, and officers found her in the middle of the roadway. I also wanted to report that he has a previous ED conviction from 2023, and he currently has a hold from Delta County with bond denied. So I would be asking that bond remain as set in this case, Your Honor.
Anything else?
No, Your Honor.
All right. Given all of those circumstances, motion for bond reduction is denied. Bond will continue in all 3 matters.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case. The cases of the people versus Brian Gerard.
Appearing on behalf of Brian Gerard. Please say your name for the record.
Brian Gerard.
Your Honor, at this time, we are requesting to adjourn this matter for pending negotiations with the prosecutor.
Probable cause conference will be adjourned to July 31st, 2025, 9 a.m. Bond will continue in these matters.
Thank you, Your Honor.
Court does call the case of people versus Tamarian Jones.
If you ever to make this for the people.
Carolyn Foster Tucker on behalf of Tamarian Jones.
Your name?
Tamarian Jones.
Thank you.
And Your Honor, we're just requesting a brief adjournment in this matter. I've talked to APA McDuffie, and she indicates that there's an offer that we need to discuss.
August 7th, 2025, 9 a.m. Bond continue.
Your Honor.
Thank you. The people versus Hyram Haywood.
Ready. Good morning, Victoria Burton here, Chief Assistant Prosecutor again here on behalf of the people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Hyram Haywood.
Your name, sir?
Hyram Haywood. All right. Your Honor, today is the date and time set for the probable cause conference. However, we are working towards drug court resolution. We need time to be able to put in a request so that we can make sure that he can be accepted to that drug court. So we're going to ask for a 2-week adjournment by the time we.
And I don't mind giving you the 2 weeks, but the timing that I was getting yesterday, I don't know that that's going to happen. To be honest with you, so I'm going to go. I certainly don't want to go so far out, but I'm going to go August 7th, just one more week out. 2 weeks. August 7th, 2025, 9 a.m. His bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case people versus Zarya Brand.
Pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecutor Attorney Alexander.
So you're under supervision of who? So it's Zenda today? You guys made up? Okay, well, never mind. I don't know. Something Douglas was in the middle of it all. All right. Permission to practice is granted.
Good morning, Your Honor. Roba Hamden requesting permission to practice. I'm so
Now,
sorry.
it's okay. You're scared? Am I doing
No,
it?
I just like my mind went blank for a
You
second.
did it? Mine does that too. Go ahead, just hold it. Do me a favor.
Requesting
Fine. Hold on.
Oh, okay.
Take a deep breath.
I'm breathing fine, Your Honor.
Apparently not.
Like my mind just went
So-
blank.
All right. All right. Just relax. Go ahead.
Good morning, Your Honor. Roba Hamden requesting permission to practice under MCR 8.120 under the supervision of Assistant Public Defender Jay Ballinger.
Okay, very good.
Sorry, Your Honor.
Oh, so it was it's his fault. I get it.
I don't know. I got
No,
thrown
no,
off.
it's Bellinger's fault, trust me.
Probably you don't have to apologize. So.
All right. Your name, ma'am?
Zarya Brand.
Thank you. All right, what are you doing?
Your Honor, mitigation information was sent to Prosecutor Zenda for review. The prosecutor is seeking adjournment to review.
To look at all of that over. All right.
I'm sorry?
That needs to be reviewed and an answer given.
Yes, and they also wanted to speak to the claiming witness as well.
Pardon?
They also wanted to speak with the claiming witness.
Yeah, okay. Probable cause conference, August 7th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. I'm sorry about that.
Sorry about what?
My mind just went blank. Like, I
No,
don't know.
it's okay. You made it through it, right?
Yeah.
Sometimes that's what we gotta do.
Thank you.
Just get to the end of it. Court does call the case, People versus Justin Hodge.
Roba Hamden. I am here with and on behalf of Justin Hodge. Can you please state your name for the record?
Justin Paul Hodge.
Thank you.
Your Honor, we would like to set preliminary examination at this time, to
All right. Is all discovery complete?
the best of my knowledge.
All right. People have their witnesses available the 29th.
Try our best.
Preliminary examination in person, July 29th, 2025, 9 a.m. before Judge Barr.
And then, when appropriate, we would like to address bond as well.
Of course you will. Go ahead.
Your Honor, my client is asking for contact with his two children to be reinstated. He advises that he would not need to be in contact with the claiming witness in order to do so.
Response.
Your Honor, we would object to any modification of bond. The defendant was on probation when this case occurred for another domestic violence case in Wayne County. He's currently being held out of Wayne for that. He currently has a hold out of Wayne for that DV with bond being set at 1,570. And this current case involves the defendant having an argument with his girlfriend, taking her phone and smashing it, and he's admitted to throwing the phone. So at this point, we believe bond is set as appropriate.
Were the children there at the time?
They were.
They were present at the time of
The 2-year-old was present.
the 2-year-old. So one of the children was there. Any other?
No, Your Honor.
All right. Motion for bond modification is denied at this time. Bond will continue with the conditions. Thank you. That's the case of the People versus Jamie Burke.
If you ever to make on behalf of Mr. Burke, who is here in person, can you please say your name for the record?
Yes, good morning, Your Honor. My name is Jamie Kaylee Burke.
Thank you.
Thank you, Your Honor.
Your Honor, we were going to be requesting an adjournment. We had the wrong phone number for Mr. Burke. We had his mother's phone number. That's how we have been reaching him in the past. She is now hospitalized. She was this week and still is. We were going to be asking for a 3-week adjournment. So until so he's
August
able.
7th, 2025, 9 a.m.
You're wonderful, Judge. Thank you very much,
Thank you
Your
for
Honor.
saying that. Not everybody agrees, but I think you're right.
Honestly, thank you.
All right.
Clearly.
Thank you.
Really appreciate that. And it was for
Thank you.
August 7th at 9 a.m.
Yes, sir.
Right here, correct? Same building, same floor?
Same building.
Fantastic. Look forward to seeing you. Thank you, Your Honor. I hope you have a good
Bad
night.
channel.
Thank you, Your Honor.
Thank you.
That's called the case, People versus Kyle Humphreys.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Humphreys.
Okay, go ahead.
Hi, Your Honor. We'll be requesting a brief adjournment for some further negotiations. Mr. Humphreys we've been working on a release for treatment with him. I've been in contact with Sarah Stewart, and he may be released for treatment soon, so that may play a part in the plea negotiations.
And that's correct, Your Honor.
All right. Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued. Let's call the case of the People versus Frank Clark.
On behalf of Mr. Clark, who should be appearing by Zoom.
Frank Clark.
Say your name again, sir.
Frank Clark.
I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of attempted resisting and obstructing a police officer. The 1-year offense. Upon a successful plea to that added count 2, count 1 would be dismissed. There is a prosecutor recommendation that indicates here of HIDA. That's the court's full understanding of the agreement.
Yes, Your Honor.
Yes, Your Honor.
Sir, can you please raise your right hand? He's gonna have to have more light where he is. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
State your name again, please.
Frank.
Full name.
Frank Clark.
Thank you.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes.
You also understand, sir, that while I'm taking your plea, froze. I don't. All right, well, you still there? Not on my one screen. Okay. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before a judge. Perry in the 15th District Court. You understand that, sir?
Actually, I didn't. Can I get a better understanding?
Judge Simpson will not be the judge who is sentencing you. You'll be sentenced in front of another judge.
Did you discuss that with your attorney, sir?
That was in one of the paragraphs. Yeah.
Yep.
You did?
Yes.
Okay, so you understand that that's what will happen. I will be taking the factual basis for your plea, but Judge Perry will be the one imposing sentence.
Yes, I understand.
Okay, and you do understand also, since you had a question about that, that you do have a right to have the judge who takes your plea also sentence you and that you're waiving that right. Sir.
Yes.
All right. Now, understanding all of that, sir, do you still wish to plead guilty to this charge?
Yes.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You went over and a advice of rights form with your attorney?
Yes, Your Honor.
And you gave her permission to affix your name to that?
Yes.
Do you have any questions regarding any of those rights?
No.
You understand that the trial rights, which are contained in paragraph 5, that you're giving up those rights as well as all the rights that are contained on that form?
Yeah. Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or on parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily?
Yes.
of your own free will,
Yes,
and because you believe that you were indeed guilty of this offense?
yes,
August 31st, 2024, at the location of East William Street near Maynard in the city of Ann Arbor, Washtenaw County, state of Michigan, did you come into contact with police officers from the Ann Arbor Police Department?
yes.
What happened that makes you think that you're guilty of this offense?
Body cam footage.
What happened on that day that was captured on the body cam footage that makes you believe you are guilty of this offense?
I heard the officer say it, talking to me.
Your Honor, may I go out there?
Have a shot.
Okay. Mr. Clark, what is it that you did after the police officer tried to speak to you that makes you guilty of this offense?
I was running.
Running from?
Yes, I was running from the police.
Okay, so the officer tried to have you stop to talk to you?
It appears so, yes.
Does it appear so, or is that what happened, Mr. Clark? Were they trying to talk to you that day?
Yes.
Okay, and did you take off right after that and run away from them?
Well, yeah, I was running, yes.
Well, when the officer said your name, did he not?
No.
Okay, did he ask you then to stop?
Yes.
Okay, and when the officer asked you to stop, did you understand that the officer wanted to talk to you?
At the time, no.
Your Honor, we likely should have done a no contest. I believe he was intoxicated at the time that this happened.
So there might be some memory issues happening right
No, not my memory. No, I recall, but
Okay, so here's what we're gonna do. Here's what we're gonna do. Where are you right now?
I'm in my home.
In Ann Arbor?
No, I don't
Ohio?
live in Michigan.
Are you in Ohio,
Yes,
Mr. Clark? Okay.
Do you remember what happened that day
yes,
clearly?
yes,
Sir, do
Your
you
Honor.
clearly remember what happened?
Yes, Your Honor.
All right. So you came into contact with the officer. What did the officer say to you?
He said, "Let me talk to you for a moment," and he was talking to me and my brother.
Okay. When the officer said, "Let me talk to you for a moment," what did you then do?
I talked to him for a second and then I ran.
Okay. At the time that you ran, did you know that was the officer done talking with you?
No.
Okay, so you knew the officer still needed to talk to you and you ran.
Yes.
Sir, you understand that if I accept your plea, that if you commit some type of misconduct between the time of this plea and the sentencing, that any sentence recommendation or evaluation of the case, the court would not be bound by. You understand that?
Yes, sir.
All
Yes,
right.
Your Honor.
Okay. Is counsel aware of any other promises, threats, or inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Defense is satisfied, Your Honor. Thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
August 1st at 8:30 a.m. with the prayer.
August 1st, 2025, 8:30 before Judge Perry.
Thank you.
On continued. Thank you.
Thank you, Your Honor.
Court does call the case People versus Serrano Johnson. Serrano Johnson.
Permission to approach the prosecutor.
Everybody want to put their appearance on and then ask?
Ron Brown appearing on behalf of Mr. Johnson.
Your name, sir?
Serrano Johnson.
You may approach.
Address bond, Your Honor.
Well, what are we going to be doing on the case first?
I got your green sheet. I forgot to give it to you.
All right. You're asking for an adjournment of the proper cause.
Yes, Your Honor.
I'll give you a date moment depending on the outcome of your bond motion. Go ahead.
Your Honor, I've provided the court with a letter from Second Baptist Church, Reverend George Waddles. The pastor is present here in court today along with my client.
see you.
My client's
Hello,
family
Pastor.
members.
Go ahead.
If released, he would live at 111 North Adams, Apartment 1 in Ypsilanti. By profession, he's a chef. He's been a resident of Michigan approximately 20 years. Like I said, he attends Second Baptist Church. He also volunteers at Hope House. And Your Honor, he's a caregiver for family members. So he has a lot of things going on. He volunteers in his community. I understand from the last hearing that he was not candid with the court as to his consumption of alcohol. But and I'm not
candid would be an understatement. I mean, he just outright lied.
Well, I wasn't there.
That makes it no less a lie.
I'm asking if you want to hear from him. A
I'll
humble apology.
I will certainly hear from him, but not if he's gonna sort of spew that garbage he was giving me the last time, because that's how he ended up in custody.
I apologize, Your Honor. I panicked. I apologize. Yes, I did consume.
Pardon?
Yes, I did consume, of course. But yeah, I panicked when I was talking to the guy. I apologize for our last encounter.
You consumed alcohol and when I tried to get you to just tell me that, you just lied to me. Right?
Yes, I tried to go back and you told me.
Pardon?
I tried to go back on it, but it's too late. I had already said it. So, yeah. I apologize, Your Honor.
So on the date that you drank, what happened?
What was the trigger? What made you drink?
Working on somebody's funeral arrangements and drink a couple beers, drink a few beers.
Okay, so did you have any O'Doul's?
At first, but.
At first, okay. How many O'Doul's did you have? Six. And then you had how many?
Labatt's about four. Sure.
Okay, now you know that's different than what you told me.
I was trying to tell you, but you told Mr. Allen.
You were trying to tell me what?
Nothing. That's what I
No,
told
no, 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 no. Let me tell you what you said, because I remember it very clearly. You told me that you had 6 O'Doul's. I told you to get to the levels that you were, if you were just drinking O'Doul's, because you were insistent on that, you would have had to have a little over a case of O'Doul's. Remember that?
Yes.
Then, at that point, you realized, well, he looks stupid, but he's not. And then you started telling me that you had 2 beers. Remember that? What?
Yes, Your Honor.
And I knew, given the level that's on here, that wasn't true. Now, the other things that you told me was that you were in treatment. Remember that?
Treatment. It's trying to go to treatment.
Well, okay. Yes.
I'm just trying to.
I don't understand the question.
You said it to me.
He said at the last.
Did you or did you not tell me that you were
wasn't
in
there.
treatment or had started treatment?
We were looking for a place to go to treatment. That's where we're starting, we're trying to go. My insurance is different.
Let me ask you this. When you made the statement about treatment, were you trying to get this court to believe that you were in treatment?
No.
You're saying no?
Self-incriminate myself. I don't know what you want me to tell
You
you.
don't want to self-incriminate yourself?
Already done.
So see, okay. And I know you know this, but I'm just going to remind you. That's what happens when you lie.
And I apologize.
I know a whole lot more than it appears that I know. And the moment you told the people at Community Corrections about O'Doul's, I knew you were lying. That was my first start. Now, if you can tell me that you can put down about a case and 2 or 1 beer, about 25 beers, and not go to the bathroom, because that's the only way that was going to happen with O'Doul's.
That didn't happen.
Yeah, so that's was kind of the stupidity of the lie. And then it just got worse for me. And then as it got worse, then you ended up going to jail.
I get it. Oh, I get it.
So how are you going to get in? You have insurance to cover treatment?
We're working on that. We just changed insurance, so it's not clear about.
His family's here, Your Honor.
They're
Oh, I
working it
know
out.
they're here, but you told me, Mr. Brown, at the bench that he's got insurance that will cover his insurance. And I'm just asking, will his insurance cover treatment?
We're working on that now to get a definite. Yes, it will cover some sort of treatment. Yeah.
Anything from the people?
Your Honor, the people do believe that Mr. Johnson is in dire need of treatment. We do have some concerns after the statement today. He may still not understand the extent he needs treatment, Your Honor. And I did have a chance to look at the letter that Mr. Brown provided that was from Mr. Johnson's pastor. It is a lovely letter and talks about the lovely things that Mr. Johnson has done. And the people aren't arguing that Mr. Johnson is a bad person at no point. And we allege that we're alleging that he committed a crime, and it would appear that perhaps the root of that could have been an alcohol addiction, Your Honor, and we think without treatment, that situation could reoccur. And it's not clear that Mr. Johnson understands that or the need for treatment, so we do have some concern there.
Anything else, Mr. Brown?
No, Your Honor.
Johnson, here's what I'm gonna do. I'm gonna first of all adjourn his probable cause conference to August 7th, 2025, 9 a.m. With reference to his bond, I will set his bond at a $25,000 personal recognizance bond. On your release, you are to report to the Department of Community Corrections for placement on a scram tether because you were on a sober. Correct. You're going to go on a scram tether, so I'm going to monitor you 24/7 for any alcohol consumption. I'm also going to order that within the next 10 days, defendant is to be enrolled in treatment. He is to notify the court that and the prosecutor's office that he is in treatment.
How many days?
He's got 10 days to do it. If he doesn't get in, I'm issuing a warrant, or he might as well just come over to jail and turn himself in, quite frankly, because I'm going to issue a warrant and I'm going to have him picked up. You understand all of that, sir?
I do.
Thank you.
Thank you, Your Honor.
No, just, we'll do that. Okay. Thank you, sir. Court does call the case of the people versus Michelle Campbell. Campbell, can you state your name, please?
Yeah.
What's your name?
Michelle Campbell.
Thank you.
Your Honor, at this time, we are requesting for an adjournment due to a pending negotiation.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of people versus Antoine Coleman.
With and on behalf of Mr. Coleman, who is approaching.
Thank you.
Your Honor, Mr. Coleman has completed his 14B recovery court evaluation. He was accepted as of 4 a.m. last night, so we didn't have time to do the plea. If we can have a very short adjournment so we can get that done, that would be great, Your Honor. Thank you.
Shortest I've got is the 31st.
That's okay. Thank you.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued. All right. Thank you, sir. Court calls case people versus Vincent Lambert. It's Mr. Brown's case. Brown.
Ron King on behalf of Lambert. Your Honor, we're requesting adjournment. I filled out the green papers.
What's the purpose of the adjournment?
Additional discovery.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Does call the case of the people versus Sean Cotton.
Stephanie Cannon on behalf of Mr. Cotton, who is appearing by Zoom, Your Honor. Mr. Cotton, could you please state your name for the record?
Great, if we could hear you, you need to unmute. Thank you.
Sean Cotton.
Thank you.
Your Honor, we are going to go ahead and set this for a preliminary exam.
All discoveries complete.
To my knowledge, yes, Your Honor.
People have their witnesses available the 29th.
Your Honor, we'll try our best, and just for the record, I discussed with counsel that Mr. Cotton's offer that was previously extended is hereby rescinded.
Preliminary examination in person will be set July 29th, 2025, 9 a.m. before Judge Washington.
Thank you so much, Your Honor.
Bond. Court calls the case of the people versus Parish Lester.
Chairman Ardashir on behalf of Mr. Lester. Say your name for the record.
Parish Lester. You're requesting an adjournment.
Yes, please, Your Honor, just to
Probable
continue.
cause conference will be adjourned July 31st, 2025, 9 a.m. Bond.
Thank you, Your Honor.
Court calls the case people versus Curtis Damon.
And Lord Yaki, Assistant Public Defender, with and on behalf of Mr. Damon. Mr. Damon, could you state your name for the court?
Yes, Curtis Mitchell Damon.
Thank you.
And Your Honor, I have been in discussion with the APA. I am asking for one more adjournment to get paperwork of Mr. Damon's progress, completion of inpatient treatment and progress of continuing treatment.
Probable cause conference, August 7th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court calls case people versus Anthony Miller.
Chairman Ardashir on behalf of Mr. Miller. Please say your name for the record.
Anthony LaGrelle Miller.
Thank you. You're requesting an adjournment.
Yes, Your Honor, and a chance to address one. Yes, Your Honor.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Your Honor, can I address one, please?
Go ahead.
Your Honor, Mr. Miller, I believe it's the second PCC, he failed to appear at his last court hearing, but he had been in custody in Wayne at the time. That's why he failed to appear. He was there from September to April, he told me. So we are going to be asking for either a reduction or a personal recognizance fund. Your Honor, he.
September to April?
Yes.
Yes, Your Honor.
He has a part-time job. He works at a gas station. He has a sister that he can go to stay with or a friend. But the only reason he failed to appear is because of that, and he will make us all future court hearing.
And how did he come back into custody?
A warrant that was picked up from release from Oakland County. I was released from Oakland County, and then
this warrant was out.
Right, they didn't pick me up. They released me, and then they picked me up and
So when were you released from Oakland County?
You told me September to April?
No, I was released from Wayne County, but I was picked up on a warrant in Oakland County after doing my 9 months from Wayne County. So I was picked up on a warrant from Oakland County 3 days prior to arriving here. And Washington County did when I was released from Oakland County, Washington County didn't come to travel to get me, and they released me from Oakland County, and then I went to Wyandotte, and then my officer was taking giving me a lift, and he asked for I gave him my name. He said, "Oh, you have to take care of warrant in Washington County." So he was giving me a lift. I asked him for a ride because, I wasn't hiding anything. So, he said it was protocol to get the name, so I gave my name. I wasn't hiding anything. He said, well, you have a warrant.
You didn't turn yourself in, I guess is my point,
Yeah.
right? You came into contact with the police. They told you you had a warrant. They told you you had a warrant. What'd you do? Did they take you into custody at that point?
Yeah,
They took you into custody and that's how you got here.
right.
Okay.
But the reason I failed to come to report to court because I was in from September, but I understand what you're saying. So,
What do you understand I'm saying?
Cause I felt, after being released, I didn't.
You should have come down here and taken care of your warrant because you knew you didn't appear.
Well, no, cause I failed to repair because I was in custody, but.
Once you were released, you didn't turn yourself in after, even though you had a warrant?
Right.
You knew you had it.
I didn't turn myself in, so, but I throw myself on the mercy of the court. I will report to I'm not a threat to.
Are you on probation anywhere else?
In Wayne County.
You're still on probation in Wayne?
Yeah, from the release of my 9 months that I did.
And what's going on in Oakland County?
Nothing.
What's different?
Everything, they ran it concurrent. They ran my sentence concurrent with Wayne County for the 9 months that I did. But as I said, I'm no threat to society and to humanity. And and I will make my court appointments. I'm not trying to avoid the law or my responsibilities. It was just that the hindrance was because I was in custody, but I feel myself.
Right, but then when you weren't in custody, you didn't come down here.
Your Honor, if I may add, having court cases in 3 different counties is likely a lot.
That's why you maybe should confine your criminal activity to one place.
Alleged criminal activity, Your Honor.
Well, they're not alleged anymore.
Your Honor, if you give him one more chance.
Yeah, I know.
Please.
I would ask you, can we follow on the personal bond that that I had. I will make all my court appointments. I'm not going to try to avoid it to come up in front of you again and say, well,
And he will contact us if he's confused or has a lot of court dates out of a lot of different counties. He will.
Where's he living?
He has a sister. He has a friend in Detroit that he could stay with, or his sister at I don't know how to say that. Wind up.
19783, still Detroit, Michigan.
And how do I know he can stay there?
Well, my probation officer, that's where my.
Go ahead.
My probation that's where my probation is located in Detroit, Michigan. So
how do you know that he could stay with his sister?
That's where my probation is.
Sure.
Was that the question?
It was.
Have you talked to your sister and she's allowing you to stay there?
Yeah.
Well, I would need some indication as to exactly where he's staying before I'm going to even consider a release. So at this time, motion for bond reduction is denied.
Thank you, Your Honor.
Marcos case, People versus Jay Dingman.
Public defender on behalf. Your Honor, I've looked in the hallway and in the courtroom. I haven't seen Mr. Dingman. I did speak to him on the phone yesterday.
Did see him?
I did not. I did speak to him on the phone yesterday. I can't explain his whereabouts today. If we could approach briefly, just very briefly, Judge.
No, we were moving along so good. Come on. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash. Your warrant will issue immediately.
Thank you.
Court calls the case People versus Carl Murray.
Can I read on behalf of Mr. Murray, who is approaching? Can you please say your name for the record?
Carl Murray.
Your Honor, we're asking for an adjournment. He does have a PCC on another case on the 22nd. We would love to resolve them together, so if we can have an adjournment to that date.
5 days out.
Yeah, I've already reviewed the discovery on this case. I just need to do it on the other case.
Two 2025, 9 a.m. Bond continued.
Thank you.
Court calls the case People versus Thomas Lee Ellis.
And Lord Yagi, Assistant Public Defender, with and on behalf of Ms. Ellis, who's approaching.
Your name, sir?
Sorry right now. Thomas Ellis.
Okay.
Your Honor, we are asking for another adjournment. Mr. Ellis did do the screening and assessment for 14B, but we need a follow-up letter from his doctor. So we're asking for an adjournment for that reason. He's going to see his doctor today. So.
Probable cause conference without objection, August 7th, 2025, 9 a.m.
August 7th. Thank you, Your Honor.
Court calls case People versus Sean Newcomb.
Good morning, Your Honor. I don't have any body cam to prove it, but I am Lauren Brown, Deputy Chief Public Defender. Go ahead and state your name. Sean Newcomb.
Thank you.
Your Honor, we are on the verge of working this matter out. We do need to go ahead and submit a request for drug court, a referral for drug court.
Okay.
Oh, I'm sorry, no, I'm drug court. Yeah, actually, I'm confused. I need some body cam. No. We're gonna waive this matter over.
You're gonna waive?
I'm looking right at the waiver right now.
Sir, you're gonna waive your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir. I'm trying to plead guilty at circuit court and get out of here.
That's too much information.
Round it up to those, Your Honor.
Where I got.
Okay.
So you understand that you will not have that hearing and you'll proceed to circuit court for further resolution?
Absolutely.
All right, people also waive their right. Preliminary examination having been waived, defendant bound over to circuit court on the single count.
Thank you, Your Honor. We acknowledge receipt of information, waive its reading in the record. My client was sending, actually, I think he needs to sign that waiver. I didn't know to sign it.
Defendant having waived former reading, standing mute, court will enter a not guilty plea. Pre-trial will be set for
July 30th at 1:30.
That's July 30th.
July 30th, 2025, 1:30, Judge Conlon.
Thank you. May we briefly address the issue about?
Yes.
Your Honor, my client's bond is currently set, I believe, at 10,000 cash or surety.
It's 5,000 personal recognizance. Unless he did something.
That got revoked, yeah.
What?
But obviously that was revoked because here he is.
What do you have as his bond?
Your Honor, if you recall, Mr. Newcomb had that incident with the saliva distributed amongst the people.
Ah, yes. Yes, I do recall. Yeah. Go ahead.
Well, Your Honor, that was some time ago. The saliva has dried up and my client was coming off competency issues.
What?
He's coming off competency issues.
I got a lot of people that are coming off competency issues that don't spit in my courtroom.
Well, Your Honor,
On people.
he is very truly sorry for that. And he would like the court to know that.
I would like
Again,
to offer apologies myself, Your Honor. Did not mean it was very, very spur of the moment and reactive. I did not think that through. It was beyond my personal actions that I can really say would be something I would normally do. It was really odd for me to have done something like that.
Really quickly, Your Honor.
Why?
Well, if I say why, then I will need to approach. Approaching things.
I can just say no and it wouldn't matter, right? Yes, you may approach.
Your
Yes,
Honor,
go ahead.
okay. So again, he was in court a few months back or several weeks back. He was going through some issues. Again, he's calm. He's much more even keeled. He's not that same guy. And I understand the contempt of court is something that the court takes seriously. I get that. He's ready to apologize and try to repair that aspect of it. What he's asking for the court is to see the person who stands before the court now, not the person who was here weeks ago, not that person, because he's not that person anymore. See the person who stands before the court now and allow him to have a return to a bond. It doesn't have to be a person. We'd be happy if the court would consider $1,000 cash or surety, but he's improved, and we want the court to see that.
At this juncture, what I'm going to do, and I mean, doing what you did that day put a lot of people in jeopardy, inconvenienced a lot of folks. We basically had to have somebody, I had to stop court, come in, clean up after you. Attorneys could not use the doorway. Your act, when it happened, clearly was intentional on your part. And bottom line is, I just don't tolerate it ever.
Yes, Your Honor, I completely understand that. And the people's reaction when it happened really floored me, and I realized what I had done immediately after I had done it. I wish I could take it back, and I know I cannot. And all I can do is offer my deepest apologies and pray for.
I am going to deny the request to reduce the defendant's bond at this time or change it. Maybe Judge Conlon, when he sees him, will feel differently, but I do not at this time. So his bond will continue. Thank you.
Thank you, Adam.
Is this all I have? All right, court does call the case People versus Cortez Gray.
I'd like to talk about appearing on behalf of Cortez Gray.
Your name?
Cortez Gray.
All right, what are we doing?
We would like to set this matter for a preliminary examination.
All discovery is complete.
Yes, to our knowledge.
People had their witnesses available the 29th. Preliminary examination, July 29th, 2025, 9 a.m. before Judge Barr. Bond continued.
Thank you, Your Honor.
Court calls case People versus Mariah Thomas.
Chairman, that is on behalf of Ms. Thomas. Ms. is not unmuted. Oh, there you go. Ms. Thomas, can you please state your name for the record?
Mariah Thomas.
Your Honor, we are going to be setting this matter for preliminary examination, please.
Discovery is complete.
Yes, Your Honor.
People had their witnesses available to, well, we gotta need a writ on this, so the earliest I can get it in, not the 20th. Set her preliminary examination in person, August 5th, 2025, 9 a.m. before Judge Perry.
Thank you, Your Honor. Thank you, Your
Thank
Honor.
you. Bond continued. Court does call the case of the People versus Samuel Peoples. single faces. Everybody gets single faces.
Stephanie Can on behalf of Mr. Peoples, who is appearing to my right. Mr. Peoples, tell the court your name, okay?
Samuel Peoples.
Okay.
Thank you. Your Honor, we have a couple of things up today. We have a pretrial, and I'm sorry, I left my paper for here. As to the pretrial, I am going to ask that it be adjourned to try to come to a global resolution. Actually, I do not have one, Your Honor. I will provide one to the court shortly. So that we can come to a global resolution on his cases. It's come to my attention today that they are thinking or considering potentially issuing out 2 more warrants that are sitting in the queue. These are all from events basically last year, all in 2024. And so I'm waiting for them all to come through so we can try and get a global resolution, Your Honor. So we're asking that the pretrials be adjourned for that purpose.
I mean, the probable cause.
Yeah, I'm sorry, the probable cause conference, yes, Your Honor.
And, Your Honor, it looks like Mr. Peoples also has another PCC for next week's docket on a different case, so I didn't know.
Well, I guess if he's got another one, I don't mind, well, I do mind, but I would put it on for next Tuesday. But I don't know if that resolves what counsel's indicating, because
There are 2 warrants that I'm still reviewing. At this point, we don't need to hold up this process for those 2 warrants. That can be.
well, I don't know that that's the case. I don't. Are they gonna be authorized? What's gonna happen with them?
So what I discussed with counsel, I just saw those last night. I thought that they had reviewed everything, but apparently they're still. But looking at what those warrants are, and some of the facts and the age of them, it's very likely that those will end up being part of a global resolution where we may agree not to authorize them anyway. So that's why I said they don't need to hold this up. But as for Mr. Peoples has a number of other cases that are charged, are authorized, but maybe misdemeanors, or he has a lot of other things out there. So I think that the overall global resolution will take care of those.
How much time?
I'm sorry, Your Honor.
How much time did you need to get that all together?
Your Honor, can we?
I would put this to the 22nd, but that doesn't make any sense. He'll appear on the 22nd. I just want to give enough time if you guys are going to try to put all of this together.
Your Honor, I am working very diligently as is the prosecutor to try and reach this global resolution.
The 2 of you working diligently.
It's rare,
Yeah,
but it does
okay,
happen.
whatever.
And so I do have documentation from various doctors and everything that I need to provide to the prosecutor's office, which I will do likely today. Your Honor, if you want to just set it with the other PCC, that would satisfy.
5 days.
Or we could adjourn this one out to adjourn the one next week.
That's what I
Okay,
said.
then we'll ask for more time, Your Honor. That would, yes, Your Honor, in your wisdom.
So why don't you do this? How much time are you gonna need to do all of this?
3 weeks. Your Honor, can we have 3 weeks?
So I will adjourn this to August 7th, 2025, 9 a.m. The first thing then that you should prepare would be a step to adjourn the other PCC, which is set for the 22nd, to this same date.
And Your Honor, it will be done. Now, Your Honor, we're asking for bond modification at this time. Thank you, Your Honor. Your Honor, I'm asking that my client be allowed to be released in this matter. I don't think that the prosecutor's office, based on our conversation, is objecting to that release. My client was released from jail. He was in the middle of a psychosis. He was having some issues. The family was responding accordingly to the issues that he was having. Your Honor, my client was then voluntarily committed 2 days after the new case. He was just in the middle of his psychosis. During that time frame, his doctor, they went through a med review, they changed his medicines. And I believe he was there for more than a month on this, getting better. I've spoken to his doctor. I have documentation. Again, I'll provide it to the prosecutor. He now has a ACT. He works with the ACT team. He has an assisted outpatient treatment program. He has an open mental health case. They visit with him twice a day. making sure he's taking his meds. He is now on an injection.
If you file a bond motion or stipulation with his plan laid out, directing that he follow it, and the monetary amount of the bond, I'll consider it. But I mean, I'll let you go through, but I'm not, I can tell you, I'm going to deny your motion right now because I don't have proof of, not that I don't believe you, but I don't have proof of anything that you.
Your Honor, I will gladly provide that to the court today. And both of the letters and all the information that I have regarding Mr. Peoples. I mean, so that you can have that, Your Honor, with the hope of getting him out. I will let the court know that he is not being properly medicated. The longer he is off of his meds, the unfortunate news for Mr. Peoples. You're fine, calm down. I'm gonna see you, you're fine. The unfortunate news for Mr. Peoples is he is on a litany of medicine, which I have provided to the jail with the pharmacy that he goes to, but they're not giving him his meds. I asked him this morning, he said he didn't have meds today. And I understand, Your Honor, and I'm gonna try very hard. I'm gonna make sure I get you that information today so that the court has it today with the hope of like.
If the parties can agree to something with the plan that he's on laid out to the court, then I will strongly consider it. But
Thank you, Your Honor.
I don't have anything.
No, that's not a problem, Your Honor. I will get it to this court.
So motion for bond reduction, I guess technically at this point is denied. Bond will continue. Thank you.
Give me a couple hours. Okay.
Court does call the case People versus Taiwan Griggs.
Stephanie Cannon on behalf of Mr. Griggs, who should be appearing by Zoom.
Yeah, well,
there's that. Your Honor, my client, he was in jail because he came in on all of the bench warrants he had because he had been in treatment, as the court knows, for so long. And he got out yesterday. When he got out, I didn't realize that. I went to jail to try and see him. Subsequently, I have reached out to see if he would talk to me or if I could find him, Your Honor. My client has appeared for every single appearance. I believe this is just a case of.
So wasn't he in custody?
I went to see him yesterday.
Provided the transportation, so of course he was here.
Yes, Your Honor.
Okay.
But Mr. Judge, hear me out on Mr. Griggs. So Mr. Griggs has been in mental health treatment and in substance abuse treatment. He had these open warrants that he had to turn himself in on. He does turn himself in on it. He is able to get bonded out. I just don't know that normally I call him and we have a conversation, Your Honor. This case has been up several times and the court is aware that he has been here every single time. He's never missed. Your Honor, how about this? If I can get him on Zoom, will you allow that?
Oh, were you done?
Yeah, I'm done, Your Honor. I'm just, sending good vibes your way.
Bench warrant will issue for defendant's failure to appear.
Thank you, Your Honor.
Bond will be set in the amount of 10,000 cash assured. Will not issue that warrant until Monday, so you can go try to find your client.
I will, Your Honor. Thank you.
Court does call the case People versus Jaylen Puster. Yeah, I think I saw the text, but I don't know what time she needed me by, but I responded back.
Good morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
And Kerma Dadush on behalf of Mr. Puster, can you please state your name for the record?
Jaylen Puster.
Your Honor, we've just received discovery. We were going to ask for an adjournment to review that and a moment to address bond, please.
What was the last thing you said?
And a moment to address bond, please. If you'll allow it.
You don't really want my answer. Probable cause conference will be adjourned July 31st, 2025, 9 a.m. As to bond.
Thank you, Your Honor. We're going to be asking for a reduction on his bond. Mr. Puster has a full-time job at the University of Michigan Building Services. He is able to go back and stay at his father's address if he is released. He is able to get released on, if Your Honor would agree to his release, he can be on a hot zone tether you know, as I believe the magistrate had ordered that if he were to be released. Don't believe he has any other cases holding him.
He does not?
I don't believe he does.
Okay.
And he just wants to be able to go back so he's able to not lose his job that he has. So for those reasons, we're going to be asking for a personal recognizance, Your Honor.
Memorial Day of this year, 3 o'clock in the middle of the afternoon, Mr. Priester and a buddy of his thought it was appropriate to go shooting through an apartment complex parking lot. One witness that he was apparently trying to get says that she has received death threats via text from him and his buddies, as well as they tried to run her off the road. 2 other innocent bystanders had bullets ringing through their apartments. One in particular was laying in the bed trying to take a nap at 3 o'clock, and she was woken up by the bullets coming through her window, entering into her bathroom. He has currently a $35,000 cash surety bond. He is only 22 years old. With this type of activity, I would certainly oppose any type of bond modification.
Well, Your Honor, if he is put on a home confinement tether with the ability to go back to work, that would perhaps ensure that he does not go anywhere that he's not supposed to be going, or do something that he's not supposed to be doing.
The unloading of a firearm, which are the allegations at dwellings where people are. I'm quite frankly shocked that his bond is so low. I'll be absolutely honest with you. And so if I were to receive a motion from the people, I would raise his bond. I am certainly under these circumstances not going to reduce his bond.
Understood.
Defendant's motion for bond reduction is denied.
Understood. Thank you, Your Honor.
Court calls case People versus Susette Hampton.
And on behalf of the people, Your Honor.
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Hampton, who's approaching. Judge, state your name, ma'am.
Susette Hampton.
Thank you, Ms. Hampton. All right.
Your Honor, we're asking to adjourn this matter to, I want to go over the video discovery with Ms. Hampton, and Ms. Londi and I have actually talked about possible resolutions.
All right. Probable cause conference, August 7th, 2025, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Court does call the case of the People versus Hampton.
Stephanie Cannon on behalf of Mr. Turner. Mr. Turner, could you state your name for the record?
Anthony Sherrod Turner.
Thank you.
And Your Honor, we are going to ask for an adjournment of this matter. We're trying to get an offer. My client has been accepted into mental health court. I have been working.
He has been?
Yes, Your Honor, he has.
Okay.
He's been accepted. I have the paperwork here, but I don't have the misdemeanor yet that would allow him to go. So while everything is filled out, I can't do anything until I negotiate this down to the misdemeanor. I thought we were on that. Attorney Childers and I, however, he's not here today, and
July 31st, 2025, 9 a.m.
Say the words, July 31st. Your Honor, can we address bond in the meantime?
Go ahead.
Your Honor, I would ask that my client be allowed to be released. You can tether him. He has a place to live. He's been in there for quite some time. It is my belief that this will go down to hopefully, with his being put in mental health court, go down to a misdemeanor. And he has already met with the mental health court. My client is super excited about it. When I met with him on Monday, he talked about it quite a bit. He likes the mental health court staff. And if the court wants, he'll even go to the next mental health court session to start this process.
Response from the people.
Other than the court's discretion, it doesn't appear that there is any significant history, and it doesn't even look like we had a cash insurance request at arraignment, so I don't.
No, he was on a PR, didn't appear, and then it was a while, we finally got him back. And started heading down this course. But where would the defendant be residing?
Did you give him your address, Mr. Turner?
312 West Huron.
Sign your name.
In Ann Arbor?
Ann Arbor.
Yeah. At this point, why don't we get the plea and everything worked out? Once he's out of his court, that court can decide, but it's what reductions.
Thank you so much, Ron.
Court calls the case People versus Ardashir Hassani.
Good morning, Your Honor. Assistant prosecutor appearing on behalf of the people.
Malika Fatima appearing on behalf of Ardashir Hassani.
All right, your name, sir?
Ardashir Hassani.
Thank you.
Your Honor, at this time, we are requesting for an adjournment.
Okay. Would you be able to accomplish your task by the 7th, or did you need one more week out? You have no idea, do you? All right, I'll just make the call. Probable cause conference, August 14th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Okay, here we go. Court does call the case of the People versus Daniel Magoo.
Good morning, Your Honor. Ashley Lottie for the people.
Sir, state your name.
I'm here on a special appearance, Your Honor. Magoo is Easy Elastical Trust, registered in Jackson County, on a case number 2522246.
Okay, is your name Daniel Magoo?
Your Honor, that is the name you seek, and it is copyrighted and trademarked.
Okay, very well. Ms. Magoo, are you represented by an attorney, or do you wish to be represented by an attorney on these matters?
I am not.
Do you wish to be?
No, not at this time.
Let me then do this. You have two cases before this court, one being the case ending, well, let me get the full case number 25F40523. In that case, sir, the complaint does allege that on March 27, 2004, you committed the offense of operating while intoxicated. Do you understand what you're charged with?
I do not.
You do not understand
There is
that?
no eyewitnesses or corroborating witnesses at all.
I'm not asking whether or not the proofs are there. Do you understand what you are charged with?
I do not.
Do you understand the notion of drunk driving?
I do not understand how I could be
We've been
charged with
through this
something without a
before on
witness.
your other cases when you represent yourself, so we'll just do it.
You're talking about the case that's in federal court right now,
You
Your
are
Honor?
before a complaint in that case for a charge of operating while intoxicated, third offense. Because it's a third offense, that is a felony. It is punishable by up to $500 to $5,000, up 1 to 5 years incarceration. The court can order probation, 30 days to 1 year in jail, or at least 48 hours must be conserved consecutively. The court can also order community service, rehabilitative programs. The court can also order your vehicle immobilized, can order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services.
As I am here and as a trust, Your Honor, I am here in exclusive equity,
You count 2 on that complaint is the charge of operating while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs, and your vehicle could be subject to immobilization.
My license is canceled, not suspended or revoked. It is canceled through the state of Michigan. Canceled.
Is the charge of escape from lawful custody. That is a misdemeanor punishable by up to 1 year, a $1,000 fine.
I was never arrested or read any Miranda rights accordingly.
Given that the defendant is talking in English, that he understands English, understands the nature of those charges and what he's charged against.
So malicious prosecution by Washington County prosecutor as usual.
Sir, there is great peril in representing yourself. You will be held to the same standards as anybody apply or
This is a matter under the Eastern District of Michigan Federal Court. Case number 2511226.
We're not represented by counsel. I would further indicate, sir, that at any point during these proceedings, if you wish to be represented by counsel, you can make that request to the court and counsel would be appointed to represent you. Because of the defendant's conduct in the past in not acknowledging the court and what the court is saying, the court does make the presumption that he does speak English. He understands that. I would further state on the record that Mr. Magoo has been through this process before. He does understand that if he does wish to be represented by counsel, the court would give him counsel or would have counsel appointed to represent him in this matter. In the case 25F30979, in that case, sir, you are before a complaint that alleges that on or about July 3rd of 2025, count 1 is fleeing and eluding 4th degree.
Added on by the
Police
prosecutor's
officer.
office after the
Sir,
fact.
that is a felony, punishable by up
Malicious
to 2 years
prosecution.
incarceration and a $2,000 fine plus court costs, mandatory suspension by the Secretary of State.
By Secretary of
2
State, anything
is
is canceled. I have no contracts with the state of
vehicle.
Michigan.
That is a misdemeanor
This
charge.
is a matter of trust, Your Honor. This is a matter of trust.
Punished
I am
by
protected
up to
under a
90
trust.
days in jail, a $100 fine plus court cost. Count 3 on that complaint alleges operating a motor vehicle without security. That is a misdemeanor, not punishable by not more than 1 year incarceration and not less than $200 nor $500 fine plus court cost. Count 4 is operating while license suspended, denied, and or revoked. That is a misdemeanor.
All of my registrations are through the federal government. I have federal government registration. I do not have contracts with the
Vehicle could
state.
be subject to mobilization. Count 5 on that complaint alleges refusal to obey refusal to.
I have an international driver's
Police
permit.
officer. That is a misdemeanor punishable by up to 90 days, $100 fine plus court cost. I would indicate to the defendant the same admonishments regarding the perils in representing oneself that I stated in the other case also apply to this case.
Were you served your
that
notice
if
and
the
summons yet, Your Honor?
wishes to have counsel appointed, the court would consider or would appoint counsel to represent him in this matter. And he apparently wishes to proceed.
Were you served your notice
Having
and summons
notice
for federal
of
court?
the charges, sir, do you wish to still proceed without an attorney?
I just want to know, where do you get
Do
your
you
powers?
wish
Are
to
you an Article
proceed?
3 judge or an Article 6 judge? Where
Do
are your
you
vested
wish to
powers? Can you
proceed
answer
without
that?
an attorney?
You can't even answer
look
me
it
what your
up.
powers are.
You can look it up.
No, you guys disconnected my access to any kind of law library or anything. You are an Article 6 judge under the Michigan Constitution. You have no authority to deprive me of my
You'll
rights.
see how much authority I have. I will assume that you wish
This is
to
a matter
proceed
of
without
trust.
counsel. I will assume you wish to proceed without counsel and that you will wish to continue to proceed.
Practicing law from the
To
bench.
inform the court otherwise. Ms. Lundy.
Thank you, Your Honor. Is the court completed the arraignment for the record at this time? on both
Well,
cases?
he had been arraigned. I was just admonishing him of the perils of representing himself and that it requires in part that I let him know what he is charged with. And I've read them kind of in fully, more so than I would have because he refuses to acknowledge those. So I am satisfied that he now knows all of the charges that are against him.
Thank you, Your Honor. The people would like to be heard on bond when appropriate.
All right. What do we want to set this for? Do you wish to have a preliminary examination, sir?
This is a matter of a federal matter now, Your Honor, under case number 2511226, under the Eastern District of Michigan, under the Honorable Mark A. Goldsmith and Magistrate Judge David R. Grand. This is, there is no proceeding here, Your Honor.
There is no proceeding. Oh, there's a proceeding.
Well, malicious prosecution is what the proceeding is.
Okay, very good. Do you wish to have a preliminary examination?
There's no proceeding, Your Honor. This is a matter that should be stayed and
What is
dismissed.
people's position on whether or not we should set this for a preliminary examination or adjourn the probable cause?
Your Honor, I don't know if the defendant has received all discovery in this matter as he is representing himself, so I would request a probable cause date, potentially.
Because you've got to send it.
Yeah, and who restricted my phone
Probable
calls?
cause conference. You know what? You're gonna have to stop interrupting. I will give you an opportunity. You've been before me before. I will give you an opportunity to say whatever you want to say. But I'm not gonna have you interrupt me and I'm not gonna have you interrupt the people when they're talking. As long as you were saying.
Thank you, Your Honor. There's video evidence in addition to the paper discovery. I've got to make arrangements with Lieutenant Arnett to work on that. So it may take just a bit longer. I would potentially look at the 7th, maybe, if the court would have entertained that. And then I will wait to be heard on bond when the time is appropriate.
I will adjourn the probable cause August 7th, 2025, 9 a.m. as to bond.
Your Honor, I've been reviewing ex-jail and I wanted to double check if the defendant had been arraigned. It's not clear to me from a couple of different things, but it does appear that he has been set with a $10,000 bond in 25F30979, as well as 25F40523, each $10,000.
Yes.
Your Honor, I do think it's important that the court have some additional information, and I would ask the court to revisit the issue of bond. First and foremost, I think it's important the court know that the facts alleged in the newest case, the 25F30979, it does include the fact that the Michigan State trooper who pulled the defendant over noted in his police report that the defendant had a license on his vehicle that indicated he was a diplomat and that he refused to identify himself. He refused for quite a bit of time. Additional units had to be brought to the scene from the sheriff's department in order to, for lack of a better term, deal with the situation. And ultimately, they were able to identify him as the defendant, Daniel Magoo. The concern with that goes along with the other case, which is an OWI. It is charged as a third. I will note that it is a true fourth, to the best of my understanding. So there does appear to be an alcohol problem going on. And I also think it's important for this court to know, because I don't know that the court knows, the defendant has a third new case, telecommunications malicious use with a domestic relationship, that is currently pending as well. He's also been set $10,000, 10% in that matter. But I think
Where is that case out of?
that case is out of 14B, Your Honor, before Judge Washington.
A co-defendants with the federal case that you guys are both in, and this is a conflict of interest as both of you guys are defendants in my federal case.
Go ahead.
I also understand, Your Honor, that there is a municipal case out of Canton Township that was set for a jury trial in April of this year, where the defendant failed to appear. And there were jurors, there was a veneer that had been brought in. And I bring all of this up to say, Your Honor, that the people are concerned about the defendant's ability to remain law-abiding, because I'll also note for the record that at the time that the new resisting, obstructing, fleeing, eluding case and the telecommunications malicious use case came up, he was in bench warrant status before Judge Slay, is my understanding, for refusing to come after the case here had been bound over, refusing to appear in person. I say all of that to say this: I do think that $10,000 is too low. And I also am going to request a scram tether, because this is an OWI fourth alleged, as well as a GPS tether, given his history of failure to appear and failure to comply with court regulations. Thank you, Your Honor.
Is the bench warrant before Judge Slay still out?
She has bond denied in her case now.
His bond's been denied in that?
Yes, that's correct, Your Honor.
Got it. Anything you'd like to say?
Anything to do with any contracts with the state of Michigan are void ab initio for a matter of law, as I have an canceled driver's license and I have an international driver's permit. And that also relates to the Canton case that they're trying to stick me for a driving unlicensed suspended citation, in which that I have an international driver's permit, making it also void. All of my matters, including the vehicle that I'm registered under, are registered to the federal government, not the state, under the Federal Motor Carrier Safety Administration. All of these charges are frivolous and a part of a long pattern of malicious prosecution by Ms. Londy, the Washtenaw County Prosecutor's Office, and quite frankly, you, Your Honor.
Hearing argument regarding bond, the court does believe that it was an abuse of discretion, given the circumstances of this defendant, to set his bond at the $10,000 figure. After hearing argument, viewing the file, the court does believe that not only does the defendant pose a risk to the public,
no
I
victims,
do believe that the defendant is a risk of flight given those circumstances, and has indeed, or at least is charged in this case, refused to obey or fled and eluded.
That was added on afterwards. The police officer did not report that at all.
The court, given those circumstances, would in each case raise the defendant's bond, grant the people's motion. Defendant's bond in each matter is set in the amount of $50,000 cash here. Thank you.
the tethers I requested, if he is able to post, Your Honor?
I will.
Thank you.
Thank you. If everybody doesn't mind, the court's gonna take a very brief recess, and I will come back and we will finish them.
All right.
I know the majority of you didn't think after this morning I'd come back, but I most decided not to. But here I am. These are, okay. Court does call the case of the people versus Jonathan Hughes.
Sherilyn Foster Tucker on behalf of Jonathan Hughes.
Client down in our jail has refused to be seen. So
Okay.
I will adjourn this out. August 7th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Court calls the case of people versus Elizabeth Hill.
And good afternoon, Laura Yagi, Assistant Public Defender with and on behalf of Ms. Hill. Your Honor, I do have a green sheet. I apologize. I'm seeking an adjournment for further discussions regarding the case.
And no objection, I did want to address,
Probable cause conference, August 7th, 2025, 9 a.m. Yes, Esteban.
simply wanted to request, there is no testing order whatsoever on this file. I provided the court, you may have the hard copy of Ms. Hill's. I think it started with Chauvelin, she may now be on scramble, vice versa in her circuit court case. I just wanted to ask that we have an order here to accompany that so that we get those results, because currently they're only being sent to.
Oh, you guys don't get them. I get them because of the game, but I got you. You're on a scram now. Right. When did you go on a scram?
They put it on me before I got out of jail, July 8th or 9th.
All right. What I will do is I'll continue the defendant's bond. And we'll order a scram tether on this case. You don't have to put another one on.
Thank God, we're out of space.
What do you say?
We're out of space.
We got two left, so we can put one on each leg. That's been done that before.
Your Honor, I'm so sorry. I'm just asking for civil standby. I think it was an oversight at arraignment, but we just need a civil standby for her to get her belongings.
To do what?
For her to get her belongings from her residence. She's been evicted, but it is the location that she's not allowed to go back to. But she was told that she could get her belongings with a civil standby, and for some reason,
I don't need to order a civil standby. You called me.
They wouldn't come out when I tried to do that. I said I had to be ordered by a judge. I'm not allowed on the property.
So I don't know if
Sheriff's Department told you that?
Yes.
If I scream loud enough, is that an order? Really? I've never. Ms. Yagi, craft an order.
Okay.
That's not how that works.
I was gonna say, I'm happy to just send them JIS if the court just indicates like, okay for
Do an
civil.
order. They want an order?
Understood.
Do an order.
Got it.
People out of room, I'll put a big signature on it.
Thank you, Your Honor.
All right, thank you. Court does call the case People versus D'Angelo Simmons. Also.
People, Your Honor.
Okay.
On behalf of D'Angelo Simmons. So the client is
Where's your client?
admitted to restoration treatment on the 14th.
So where is he?
Not here
Why?
because he's getting treatment.
You got plenty of people getting treatment. Why is your client here?
We would like to.
Okay, I'm messing. Look, he's not here. He's in the forensic center. There was no way.
So we would like to adjourn this matter.
You had no clue.
Um,
Kind of did, but
I-
never mind. All right. probable cause conference, we'll adjourn this out to the 8th or the 7th, I'm sorry, August 7th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Oh. Okay, all right, let me. Hold on one moment, folks. Where's the text? Oh, there you go.
I'm tucking in my shirt for you.
No, you don't kill. Right, you solemnly swear for the information contained in the search warrant affidavit is true to the best knowledge information. Court does call the case of the people versus Dutton Howard.
Alexander on behalf of the people.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Howard, who is now approaching the podium.
State your name.
Dutton Howard. At this time, Your Honor, we'll be requesting an adjournment to have video discovery be provided.
All right.
And here's a green sheet for you, Your Honor.
Okay, you're looking for video discovery.
That is correct, Your Honor.
During this to August 7th, 2025, 9 a.m. Bond continued.
Okay.
Thank you.
Your Honor.
Court does call the case people versus Sherry Hughes.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Hughes, on behalf of Mr. Gaddy. Not with Ms. Hughes, Your Honor. My understanding is that our office has attempted to reach Ms. Hughes several times and we've not been able to get in contact with her. I'd ask for an adjournment for the record.
Bench warrant will issue bond 10,000 cash surety. That warrant will issue immediately.
Thank you.
Thank you. Court does. Yes. Go ahead. You may.
Good morning, Ms. Liliana. You're in front of the Honorable J. Cedric Simpson out of the 14th District Court, Washington County, State of Michigan. We need your assistance with one matter this afternoon. Our number is 1423.
Yes, certainly. I'm ready with your instructions.
Can you please raise your right hand to be sworn? Do you solemnly swear or affirm that you'll interpret accurately, completely, and impartially, using your best skill and judgment, and translate from English into Spanish and from Spanish into English in the manner now before the court, so help you God?
Yes, I do.
All right. Court does call the case of the people of state of Michigan versus Horge Lopez.
Jennifer Douglas for the people. Sorry, Jennifer Douglas for the people.
No le seré su intérprete de español el día de hoy. Este sería el caso del estado de Michigan contra Horge Lopez. De parte de las personas del estado sería Jennifer Douglas.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Lopez.
Y a favor de parte del señor López, abogado de la Oficina del Defensor Público, Nicolás Bukovich.
Defendant is requesting an adjournment in these matters. I will adjourn the probable cause hearing to August 14th, 2025, 9 a.m.
Your Honor. Sorry.
Pero el acusado estaría solicitando que se aplace esta audiencia para tener la audiencia de causa probable. Se estaría aplazando, moviendo para el 14 de agosto del 2025 a las 9 a.m.
Yes.
I do have a meeting set up with Mr. Lopez, and
I understand. I read the form, which shouldn't say what it says, and we'll talk about that.
Understood. Thank you, Your Honor.
Sí, entiendo de que bueno, mencionaba su abogado de que tenía una reunión con usted, con el señor López, y después menciona de que sí, entiendo, leí lo que dice la forma, que no debe decir eso, y vamos a estar abordando eso.
Bond will continue. Thank you.
Se va a continuar, gracias.
All righty, thank you, Madam Interpreter. Can counsel on the last case approach, please? Thank you, Madam Interpreter.
Sí, have a good day. Bye.
Did not hear you call.
Okay. Court calls the case of the People versus Shaffy.
APA Rachel McDuffie for the people.
Good afternoon, Tina Sachs on behalf of Mr. Shaffy.
Mr. Shaffy here. Yeah, very. Sir, please state your name.
Rashad Shaffy.
All right. All right, what are we doing on this case?
Your Honor, my understanding is that Mr. Shaffy is currently set for preliminary exam, which are being adjourned because he has been in treatment, got out, is in treatment again. So we, I believe counsel's request is to adjourn this case. I want us to quickly address bond on this one as well, just for the same administrative purpose I did on the other case I had.
All right. How much time, Ms. Saxon?
Your Honor, I'm asking for 3 weeks. Mr. Shaffy's supposed to still be in the program for a total of 28 days. He just went in on the 14th, so I was hoping to.
Gotcha. All right, I'll adjourn this then to August 7th, 2025, 9 a.m. All right.
Thank you.
Master bond.
And Your Honor, regarding bond, there is a testing order on this case, but I just provided the court, I think via email, it might be in the file. Ms. Shaffy's technically in violation on this case, but Community Corrections has 2 sets of reports that don't overlap. So I just provided the court with his other report from those previous 2 cases that were set for exam so that you had a copy. It appears that he briefly relapsed and then went back into treatment. So
I was in a motorcycle accident, so I missed my time.
Mr. Shaffy.
I'm sorry.
He was, I remember from the last time, there was an accident, he was in the hospital and he missed his testing. And then he's good with me.
I just provided a copy because they didn't send it to me.
All right. Okay, thank you, bond.
Thank you,
Your Honor.
Court does call the case People versus Emily Bates.
Emma Dadish on behalf of Ms. Bates, who's appearing on Zoom. Ms. Bates, can you please state your name for the record?
Emily Bates.
Thank you.
Your Honor, we are going to be asking for an adjournment. We need to get proof from Ms. Bates regarding treatment in pursuit of a plea offer. So we're gonna be asking.
August 7th, 2025, 9 a.m.
Thank you.
Bond continued. Thank you, Ms. Bates.
Thank you.
Court calls case People versus Desmond Jones.
Hey, Rachel McDuffie for the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Jones. Your Honor, I will need to fill out a green sheet. I did not have contact with Mr. Jones. So I will.
Because if you had contact, you
I would have told
about
him
appropriately
that he needs
dressed.
to wear pants. Yes, Judge.
Yes.
Yeah. So I will
We
get a
won't
green
see
sheet.
that the next time if I grant you adjournment.
No, absolutely not. Yes, he will have pants on. If I could have an adjournment so that I can get updated contact information with Jones, and I'll get a green sheet to the court.
July 31st, 2025, 9 a.m.
Thank you, Judge.
I'm continuing.
Thank you.
That's what it sounds like. Jay does not, don't listen to Jay. She has no idea. Court calls the case People versus Dominic Kelly Payne.
And Assistant Public Defender Hannah Apple appearing on behalf of Mr. Kelly Payne, who I do not see here in the courtroom. Judge, I did talk to Mr. Kelly Payne yesterday. He did have court in the 22nd Circuit Court this morning. My understanding in corresponding with Ms. Nevesky that he was there, and Judge Kunke and their team came up with a plan of action for Mr. Kelly Payne. I expected him to be here in person. He
Did
discussed
he
this.
like the plan of action they came up with?
Yes, I believe so. It allowed him to remain out of custody and a treatment plan so that he can stay compliant with drug treatment court. I don't know why he hasn't made it here yet. But considering that information, I'd ask the court for an adjournment.
That and probable cause conference will be adjourned July 31st, 2025, 9 a.m.
Thank you, Judge.
That was so nice of me. Miss Apple has a nice way of asking. Don't buy it all the time, but. Court calls the case, People versus Coran Lee Master.
People.
Probably just LeMaster.
My name is Alex Parks. I'm requesting permission to practice pursuant to Michigan Court Rule 8.120 under APD Hannah Apple.
She.
Fantastic. Yeah.
Okay. She wants to keep handling cases. All right, your name, sir?
Corrano Master.
All right. Permission to practice is granted.
Thank you, Your Honor. We're requesting adjournment in this matter to give us more time to discuss with our client.
Discovery. All right. Probable cause conference will be adjourned August 7th, 2025, 9 a.m. Or as your invite indicates, bond will continue. Thank you. Thank you, sir.
Thank you.
Court calls the case of the People versus Derek Martin.
That is for the people. Patrick Cannon on behalf of Mr. Martin. Mr. Martin, when you are at the lectern, please state your name.
Derek Martin. Thank you.
And we are simply requesting an adjournment, Your Honor. There's some outstanding discovery and I don't have one.
Get the form to us. I'll sign off on it. July 31st, 2025. Bond.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Harold Martin.
Echelon of the people.
Assistant Public Defender Nicholas Buckovich on behalf of Mr. Martin.
Harold Martin.
Yep, yeah, no, I have been trying to make contact with my client. I was unable to do so. I'll be requesting an adjournment.
Your Honor, can I ask a question as to previous eventual issues?
As to what?
I think there's been previous warrants in this case, is that correct?
I do not know right off the top of my head, but one, yes, there was one April 24th.
Are you able to tell if he posted the bond?
I don't see it as posted, but it was a recall.
And I will also note for the record, there was another bench warrant that was issued on April 4th, 2024, that I think got recalled.
I don't know.
Okay.
We can assume for the sake of argument it was, so. Bench warrant in this case will issue. Bond will be set at 10,000 cash surety. That warrant will issue immediately. Court calls case People versus Robert Martin.
And Assistant Public Defender Nicholas Buckovich on behalf of Mr. Martin, who is now approaching the podium.
Your name, sir?
Robert Martin.
Thank you.
Today, Your Honor will be waiving a preliminary exam, so Mr. Martin can pursue offer under 7411 in the circuit court.
Sir, is that correct? You're waiving your right to a preliminary examination?
That is correct, Your Honor.
You understand that's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single count.
And I do have a waiver filled out for you, Your Honor.
It's your turn.
Yes, Your Honor. As it relates to the charges, we will waive a formal reading and my client be standing mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pre-trial in this matter will be set
September 4th at 1:30 with Judge Slay.
September 4th, 2025, 1:30, Judge Slay. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you.
Your Honor.
Court calls the case of the people versus Makisha Melchor.
Okay, Richard McDuffie for the people.
And Laura Yagi, Assistant Public Defender, hopefully with and on behalf of Ms. Melchor. I know she was having some issues logging in. Ms. Melchor, can you unmute yourself and say your name for the court?
Oh, there she is. All right, can you, there you go, you have it. State your name.
Mikesha Melcher.
Okay.
Your Honor, we are respectfully asking that this case be set for exam,
All discovery is complete.
to my knowledge.
And I just want to confirm, apparently there was some discussion of a misdemeanor offer if was submitted that Ms. Melcher completed treatment. I'm confirming that potential for offer things, and that, we're coming, I can't talk, sorry.
That, I guess I'm confused. There was no offer, and so we're setting it for exam. I'm not.
That's the correspondence that we had, but that's okay. Well, Your Honor, can we pass it for about 30 seconds, please?
Why? Is there an offer or not?
Counsel emailed me, requesting an update on a potential offer previously discussed. I responded asking if she had the documentation that was requested for that offer. And here we are. So.
Your Honor, we're setting it for exam. There's no offer.
Preliminary examination in this matter will be set for July 29th, 2025.
Thank you.
9 a.m. before Judge Washington. Bond will continue.
Thank you.
Thank you.
Thank you, ma'am. Court does call the case. People versus Jordan Miller.
Hey, Peter Richard McDuffie for the people.
Ron Brown appearing on behalf of Jordan Miller. Green sheet.
You may. Yes, Mr. Murphy.
Please state your name.
Jordan Miller.
We'd ask for the adjournment to obtain additional discovery and review it.
Council approach. Conference in this matter will be adjourned August 7th.
Thank you, Your Honor.
2025, 9 a.m. Bond continued.
I'll talk to my client.
Court calls case People versus Lanish. I got that right. Mitchell.
That is for the people. This is the public defender on behalf of Ms. Mitchell, who's approaching now. Your Honor, we are asking for an adjournment. I know that Ms. Douglas has been working tirelessly to try to get us the video discovery on this case, but it is still outstanding from several agencies. I also received a bond violation report, which I assume the court is looking at now.
Yeah.
Ms. Mitchell did provide me with her medical marijuana card. I do have it if the court wishes to look at it. It is valid. I showed this to Ms. Douglas, and I'd asked her to provide a copy to Community Corrections.
Yes.
There was some misunderstanding regarding that, but she does now have a valid medical card.
How much time were you looking for, Ms. Hamilton? I realize you guys are trying to work on this, but
yeah,
how much more time did you need?
Yes, Your Honor, I've had, for some reason, trouble getting video on it. I got some more this morning. If we could have a couple weeks, I do want to look at it because the video I had before was not of what I was expecting it to be of.
Okay.
So, I just want to make sure we're actually getting this council. What
She said, okay. August 7th, 2025, 9 a.m.
August 7th.
Bond will continue. Thank you. Court calls case People versus Antoine Patterson.
Families on behalf of the people standing for the mother of
And Assistant Public Defender Jay Bellinger on behalf of Mr. Patterson, who approaches. Mr. Patterson, can you please state your name for the record?
Antoine Patterson Senior.
All right.
And
go ahead.
I'm sorry, Your Honor. My understanding is that there is an agreement today and my client will be taking a no contest plea. I have, I believe in your file, there should be a previous advice of rights. However, if the court is not in receipt of that, I do have an updated copy and I did sign that with my client's permission.
I don't know. Why don't we just have, I want to make sure I didn't get the plea form before. Okay, the plea form indicates that the defendant will be pleading no contest to the charge of domestic violence. Upon a successful plea to that charge, count 1 would be dismissed. Defendant is agreeing to 2 years probation, no contact with any minor children other than his biological children, but only through CPS recommendation or court order, and incidental contact at a bus stop. The offer is contingent upon there being no violations, no assault or contact with anyone since the assault that underlies the current case. Also, there is a sentence agreement, which I can't bind the court to, but for 7694A with all treatments recommended by probation. That's the court's entire understanding of the agreement.
That is our understanding as well, Your Honor. That's our understanding.
Attendance 1.
You solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Go ahead and state and spell your name again.
Antoine Patterson Senior. That's ANTUAN
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
All right. 2 things about it I have to make sure you understand. First thing you need to understand is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Basis for the no contest plea?
Fear of potential civil liability, Your Honor.
All right. Sir, understanding all of that, you still do wish to plead no contest?
Yes, sir.
And to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind?
Yes, sir.
You signed an advice of rights form?
Yes, sir.
Any questions regarding those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
All right. Court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 24-52383. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of dispense. Sir, I do have to advise you that if I accept your plea, from the time of this plea to the time that you were sentenced, if there is indeed a violation or misconduct as defined by the Michigan court rules, and you're engaged in that 2 things. One, you would not be able to withdraw your plea. You understand that?
Yes, sir.
And you understand any sentence agreement and or recommendation the court would no longer be bound by?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other? And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right, we'll accept the defendant's plea of no contest to count 2. My paperwork. Plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A for probation, or I'm sorry, 14B probation. Sentencing in this matter will be
August 18th at 10 a.m. with Judge Washington.
August 18th, 2025, 10 a.m. Judge Washington. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Danielle Pressey.
National Line of People. Assistant Public Defender Hannah Apple appearing on behalf of Ms. Pressey. We say your name for the record. Danielle Pressey. Thank you. Your Honor, I'm sitting in for Mr. Gaddy. We're asking for an adjournment. There's some mitigation information that's been being finalized and going to be presented to the prosecutor. All right. Shortly.
Probable cause conference will be adjourned August 7th, 2025, 9 a.m.
Thank you, Judge. Thank you.
Thank you, Your Honor.
August.
Bond will continue. Court does call the case People versus Jody Ann Russell.
And Lord Yaki, assistant.
Jody and Russell, can you hear me?
Yes, we can hear you. Thank you.
Okay, no problem.
You're requesting an adjournment.
I am, Your Honor.
I will adjourn the probable cause conference August 7th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
And Laura Yagi, Assistant Public Defender, with on behalf of Mr. Schultz. Mr. Schultz, can you state your name for the court?
Schultz? If that's you, wave your hand. Oh, there you go.
Yep.
You're on. Okay, state your name.
Jeremy Schultz.
All right, very good.
Your Honor, I'm requesting an adjournment in these matters for some updated paperwork and continued conversation with APA.
All right. In both cases, probable cause will be adjourned to August 7th, 2025, 9 a.m. Bond continues.
Your Honor, can I?
What, sir?
I was gonna say I'm going back to work. I was wondering if I could do it via Zoom for the 7th.
You talk to your attorney about that.
I'll file it for you, Mr. Schultz. We'll follow up.
Okay.
All right. Thank you.
Thank you.
We'll call the case People versus Joseph Smith. No.
Assistant Public Defender Nick Bukovich on behalf of Mr. Smith, who's appearing via Zoom. I did have a contact with Mr. Smith before the docket started, indicating that he was on the Zoom.
He was on it?
I'm here.
Yes.
I'm here.
Oh, that's you. Okay.
Mr. Smith, can you please state your name for the record?
Joseph Smith.
All right. Okay, what are we doing in this case?
At this time, Your Honor, be requesting an adjournment for some further negotiations and also determine if there's any outstanding video discovery in this matter.
All right.
I do have a green sheet for you.
I'll adjourn this matter to August 7th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus Myra South.
Hello.
Hello, state your,
My name is Alex Parks. I'm requesting permission to practice
again?
again.
Oh, come on, girl.
Why are you doing it again?
I only do it once.
Who's your supervisor?
Miss Hannah Apple.
Did Miss Apple tell you you only needed, that I only needed it once per session?
I
Did
must
she
have,
tell you
she
that
must
or
have
no?
told
Don't
me.
defend her. Did she tell you that?
I'm sitting in for Mr. Daddy.
She's,
That's
So are you normally with Miss Apple or Mr. Gaddy?
Mr. Gaddy.
Okay, now I get it. Okay. It's not Miss Apple's fault. Okay. All right, you're requesting an adjournment.
Yes, we are.
All right. Probable cause conference will be adjourned August 7th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, ma'am. Court does call the case of the people versus Virgil Stafford.
There he is. This is Public Defender Hannah Apple, appearing on behalf of Mr. Stafford, who's from now. Mr. Stafford, will you state your name for the record?
Virgil Stafford.
In your honor, we have reached a resolution.
Yes, I do see. He's going to plead guilty to.
An attempt, count two, an attempt resisting obstructing.
Yeah, the problem is all right, I'll fix it. But it just states next to the primary charge. The PAC code is for the attempt, but got it. Okay.
Thank you.
He's going to be pleading guilty to the charge of attempted resisting and obstructing an officer, the 1-year offense. Upon a successful plea to that charge, that count two, count one would be dismissed. There is an agreement by the defendant that he will comply with all court orders for mental health treatment, comply with all medication plans. Defendant has a probate case, I'll just leave it there, that was transferred to Genesee County in June of this year. That's the court's full understanding.
Yes, Your Honor. That's correct, Judge. Thank you.
All right. May I have him sworn?
Someone swear or affirm the testimony about truth, whole truth, and nothing but truth. So, lower your hand, spell, and say your name again.
Virgil Virgil Stafford, Stafford.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Bravo in the 15th District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights. Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Okay. Were you on probation at the time of this offense?
Yes.
All right. You understand that your entry of a plea in this case could be considered a violation of that probation.
Yes.
You understand that if it is considered a violation, that court could sentence you to the maximum allowable under that other charge.
Yes.
And understanding that, you still wish to plead guilty to this charge?
Yes.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense, sir?
Yes.
On the date of January 16, 2025, at the location of 300 Briarwood Circle, City of Ann Arbor, Washtenaw County, State of Michigan, did you come into contact with officers of the Ann Arbor Police Department?
Yes.
What happened?
Sorry.
Go ahead. You may, Vladimir.
Thank you, Judge. On that date and time, you came into officers that were with the Ann Arbor Police Department, correct?
Yes.
And you knew that they were officers with AAPD?
Yes.
Okay, and they ultimately asked you to step out of your vehicle, correct?
Yes.
Okay, and you complied with that, but then they informed you that they were going to detain you, correct?
Yes.
And to place your hands behind your back?
Yes.
Okay, and you did not comply with that order,
No.
correct?
Yes.
Great.
All right.
Defense is satisfied.
Okay. Very good. Sir, if I accept your plea, I do have to advise you that if between today's date and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you first of all would not be entitled to withdraw your plea. And secondly, any sentence agreement or evaluation, the court would no longer be bound by. You understand that?
Yes.
All right. Counsel, are you aware of any other plea promises, threats, or other inducements which have caused this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, sir.
Defense is satisfied. Thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
July 29th at 9 a.m. with Judge Bell.
July 29, 2025. What time, I'm sorry?
9 a.m.
9 a.m. with Judge Balwell. And will continue.
Thank you, Judge.
Court does call the case of the people versus Darnell Taylor.
Alexander, on behalf of the people, Your Honor, she is in the hallway charging his tether.
Doing what?
Charging his tether.
On our bill? Go ahead. I'm talking about. That's why our DT bill's so high. You can come here to charge it.
Thank you for my appearance on me. On behalf of Mr. Taylor, will you state your name for the record?
Darnell Taylor.
Thank you. Your Honor, we are asking.
How long was he charging for?
Oh, maybe 15, 20 minutes?
35.
35, just kidding. On my time.
35? Figure out the DT rates. Give me a number. We'll make it pay. All right, go ahead.
Your Honor, Mr. Taylor is asking that this matter be set for a preliminary exam.
Media has not been sent over to defense counsel, nor has the 911 call. The media notice was made, I believe, 2 days ago, and the 911 call still has not come in yet, so they do not have media discovery nor 911 call.
And Your Honor, that is correct. I informed Mr. Taylor of that. I informed him that the court would be asking if discovery was complete. We do not have the video. Mr. Taylor is still insisting and requesting that the court proceed with the preliminary exam. I fully advised him of the risks of that, considering one of the allegations is from the back of the patrol vehicle. We do not have video of that, but he is asking that the matter be set for an exam.
Sir, you understand that could be a problem for you? Because if the discovery comes in and people have it, your counsel hasn't had a chance to look at it, you're not going to get an adjournment of these proceedings.
Yeah, I understand.
You understand that?
Yes, Sean.
Do you think it might be better that your attorney would be able to look at what it is, particularly since some of it was involved in what I understand the back of a police vehicle, prior to making or being able to fully advise you as to how to proceed?
Yeah, Sean, I understand. I mean, at the end of the day, I honestly don't think it's gonna make a difference.
So you got your law degree where?
I don't.
Yeah. And I think she said it, so it's not really impinging on your privilege. She's advised you that you probably should wait till they can fully assess it.
Did I advise you of that?
Yeah, she did.
Okay.
Don't you think it might be advisable for you to follow your lawyer's advice?
I do, Your Honor. But at the end of the day, I mean, I know what I did.
Well, no, whoa. I don't want you.
Okay. Well, I didn't do.
I do know. Hold on. Here's what we're gonna do. Over your objection, I'm going to adjourn it. I'm gonna make sure that it's fair to you and that you have what you need to make a proper call rather than rushing into it. Okay.
I understand. My main thing was I'm on this tether and
I know, but you don't want a circumstance where, and I'm not saying that it will, things can get much worse for you. Let your attorneys do the job for you. Okay.
All right.
You got good attorneys around you. Let them do their job. Okay.
All right, Your Honor.
All right. So we think we'll have that by when?
Probably sometime next week, Your Honor.
Okay. So if you get it next week, here's what I'll do. I won't put it out far. I'll put it out, instead of going to the 7th, I'll go to July 31st.
Thank you.
Okay. 2025, 9 a.m. And then at that point, after you've seen everything that's there, and your attorney, most importantly, has seen it, then you can make a decision.
Thank you, Judge.
Fair enough?
Yes, sir.
All right. And just because you actually listen to me, I'm not going to make you pay for the use of electricity.
I appreciate it.
All right. Take care.
Thank you.
Court calls the case, People versus Vershawn Vincent.
Ass-
Testimony for the people.
Sorry. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Vinson. Your Honor, I don't believe with Mr. Vinson. I will take the blame for this one. Mr. Vinson typically appears on Zoom. That was my apologies in missing the deadline. I submitted it late. I've had communications with Mr. Vinson up and through today and just a few minutes ago. He lives in Detroit. He does not have transportation. But he was not able to make it here today. He tried everything he could over the last 24 hours to get a ride. But unfortunately, he could not appear in person. We do have a misdemeanor resolution on this case. We just need Mr. Vinson to get here.
Gosh, she's so nice and eloquent. I hate being nice. People have any objection if I adjourn this out, given those circumstances? Who is it, Londi?
Yeah.
Oh, boy. This could get bad.
The only problem is Mr. Vincent has a very significant history of failing to appear.
He does, but I think since that,
Since he's been coming on Zoom, it's been better,
yes, exactly. And
but it's still not great.
If I could let the court know,
wow,
just one additional thing. Mr. Vinson, we had a lengthy conversation yesterday. He's prepared to accept the offer. I informed him that we'd be asking for one more adjournment. And then my request is that he appear in person in 2 weeks at the adjourned date so that he can sign the waivers. We can make sure to have that conversation so that everything is signed and done. He informs me that he'd be able to get a ride, that's enough notice, and he would be here. So if the court is gracious enough not to issue the warrant, I will ensure that everything that I can do, that he is here in person and he has enough time.
noting the people's reluctance to agree, and I understand, and looking at the file that he's had some issues. I'm going to grant the request. I'm going to adjourn it out to July 31st, 2025, 9 a.m.
Thank you.
Continue. Thank you.
Thank you, Judge.